So I'm going to be reading from my system so that I can make necessary corrections as I read along.
As the court pleases.
As the court pleases.
This is the judgment of the court. The claimant, by a complaint filed on 25th August 2023, sought the following claims. Now, before I continue, I just need to run with you that I may not necessarily read the entire content of the judgment, as some of them are already captured in all of them are already captured in the body of the judgment, and they are lifted from either the pleadings of the parties or the necessary regulations and laws cited. But I have cited them verbatim in the body of the judgment. So as when I consider it necessary, I'll skip certain parts of the judgment. Although I can assure you that you can have your judgment before the end of today if you're in Abuja. And if you're outside Abuja, latest by Monday. Thank you.
Commander, please.
The claimant sought the following claims against the defendants. Now there are 9 claims, which I have reeled out verbatim in its entirety. And then I have again summarized the case of the claimant as contained in his deposition. There is also the defense, which I have again summarized. And then I have mentioned the final written addresses of the parties. I'll go straight to the decision part of this judgment. I have examined. Please, can you tell counsel to mute the mic so that I can read undisturbed? If you need to call Counsel Mohammed, please do so that he can mute his mic. I have examined the pleadings of the parties and the evidence adduced by them. I have also considered the submissions. I think this is disturbing my judgment. So, okay. Yes, ma'am. I've examined the pleadings of the parties and the evidence adduced by them. I have also considered the submissions in the respective final written addresses. In my view, the issue to be determined in this case is whether the claimant proved the claims sought by him and is entitled to judgment in his favor. Now, before I determine the issue, it is necessary to comment on the status of the evidence adduced by the defendants in this suit. In all the paragraphs of the statement of defense, the defendants were merely admitting or denying the averments in the statement of claim, or that it cannot admit or deny the claimant's averments. The only facts pleaded by the defendants are those in paragraphs 11, 13, and 17 of the statement of defense, where the defendants averred that the documents required from the claimant were compulsory for the processing of the death benefits of his late father, and that the letters pleaded by the claimant in paragraphs 22 and 23 of the statement of claim were not received. In paragraph 17, the defendants pleaded that the period between the death of the claimant's father and the period he came forward to claim the benefits was too long, and the claimant had forfeited the claim. I have earlier set out the evidence adduced by DW. His evidence, other than what he said in paragraph 10 of his witness statement on oath, was not pleaded by the defendants. It is trite that evidence adduced on a fact not pleaded goes to no issue. See Adejumo versus Ayon Tegbe, 1989. Ayonfulu versus Mecca, 2014. The evidence adduced by DW on facts not pleaded by the defendants goes to no issue, and I will disregard them. The case of the claimant is that his father was a lieutenant in the Nigerian Army, and he was in active service when he died on 6 April 1981, having served 15 years in the Army. After his father's death, the defendants have not paid the emoluments, death benefits, pension, and gratuity of his father up to the date the claimant filed this suit. The claimant also said he is the named next of kin of his father, entitled to be paid his father's entitlements. In relief 2, the claimant sought a declaration that the non-payment of of the emolument, death benefit, pension, and gratuity of his late father to him as next of kin amounts to violation of the Armed Forces Pensions Act, AFP Act. I have examined the AFP Act. What it provided for as payable to a deceased officer are pension and gratuity. The Act did not provide for payment of emolument or death benefits. The claimant too did not prove what the emolument or death benefits were and how they accrue as part of what he can claim upon the death of his father in service. The claimant's claim in Relief 2 and all other reliefs will be limited to his entitlement to pension and gratuity, which the AFP Act provided for. In paragraph 7, 9, 14, and 17 of the Statement of Defense, the defendants admitted the averments of the claimant in paragraphs 14, 16, 17, 24, 31, 32, 33, and 34 of the Statement of Claim. While in paragraphs 3, 4, 6, 8, 10, 11, 12, 15, 16, 19, and 20, the defendants pleaded that they are not in the position to admit or deny the averments in paragraphs 6, 7, 8, 9, 10, 12, 13, 15, 18, 19, 20, 21, 25, 26, 27, 28, 29, 30, 36, 37, 38, 39, 40, and 41 of the Statement of Claim. It is right that the averments in a statement of defense that the defendant cannot admit or deny the averments of the claimant, a plaintiff, is an insufficient traverse and amounts to an admission. See Oseni versus Dawodu, 1994. Idris versus ANPP, 2008. Ogbeide versus Osula, 2004. Consequently, all the paragraphs of the Statement of Claim which the defendants said they cannot admit or deny are taken to have been admitted by them. By the defendants' admissions, the following facts pleaded by the claimant are not in dispute. There are 6 of those facts listed. Lieutenant Abakiri was an army officer who died while in the service of the Nigerian Army on 6 April 1981 at his last place of posting, which was the depot, Zaria, Kaduna State. 2, the claimant is a son of late Lieutenant Abakiri. The first and third defendants wrote the letter dated 19th October 2022, Exhibit NA13 to the claimant, confirming and acknowledging the claimant as the next of kin of his late father. 3, after the burial of the claimant's father, the defendants did not pay his pension and gratuity at the time. 4, the claimant first contacted the defendants for the payment of his father's pension and gratuity in August 2022 when he wrote Exhibit NA2 dated 22nd August 2022 to the first defendant. 5, to process his father's pension and gratuity, the defendant's depot, Zaria, Kaduna State, requested the claimant to present his late father's letter of condolence, Nauticus, Unit Part 2 order, service document, and affidavit of next of kin. But the claimant did not have these documents, except the affidavit of next of kin, which the claimant later obtained from the FCT High Court on 23rd May 2023. And 6, as a result of the claimant's inability to submit the requested documents, he has not been paid his father's pension and gratuity till the time he brought this action. It is therefore clear from the evidence adduced by the claimant and the facts admitted by the defendants that the pension and gratuity of the claimant's father has not been paid since the time of his death in 1981 to his dependents, who include the claimant as the next of kin. The claimant said in his evidence that his father was in the service of the second defendant for over 15 years as at the time he died. The defendants did not controvert this evidence of the claimant. In fact, the defendants admitted that fact in paragraph 3 of their statement of defense. It is therefore not in dispute that the claimant's father died in service and he served for over 15 years before his death. By sections 3.1 of the AFP Act, by section 3.1 of the AFP Act, the claimant's father served for the number of years to qualify him for pension and gratuity. And by section 7.1 of the AFP Act, the next of kin or dependents of the claimant's father are entitled to be paid pension and gratuity upon his death in service. I have seen Exhibit NA13 written by the second defendant to the claimant. In the letter, the claimant was informed that the available records in the second defendant's headquarters show that the claimant is the authentic next of kin of his deceased father. The claimant was also advised to proceed to his late father's unit to process his father's benefits. Thus, the benefits have confirmed that the claimant is entitled to receive his late father's pension and gratuity from the defendants. In paragraphs 33 and 34 of the evidence of the claimant, he said, since he was not paid his father's entitlement since 1982, it can only be fair if the current rate at which an officer of his father's rank is paid be used to compute and pay him his father's pension and gratuity. Then in reliefs 5 and 6, the claimant sought an order directing the third and fourth defendants to compute and pay the pension and gratuity of his late father in accordance with the current schedule and scale of computation applicable to any equal ranking retiring officer at par with his late father. Put in simple terms, what the claimant is asking is that the pension and gratuity which ought to be paid after his father's death be computed using the monetary scale being used as at today to pay officers of his father's rank. Meanwhile, the claimant's father died over 45 years ago, and in all these years, the claimant did not take steps to process payment since 1981 until 4 years ago. In any event, the critical question arising from this claim of the claimant is whether, by the provisions of the AFP Act, the claimant is entitled to the rate of pension as at date or the rate as at the time of the death of his father. Section 7 of the Armed Forces Pensions Act provides as follows: pension and gratuity to be paid to dependents, etc., where a serviceman dies in service. Sub 1, where a serviceman dies in the service after the completion of the minimum period of qualifying service, they shall be paid to his legal personal representative or to any person being a relation or dependent of such serviceman. A gratuity equal to 1 year's salary of such serviceman up to 31st March 1978, and the gratuity he would have been entitled to if he had retired on the date of his death after 31st March 1978. And B, such pension as would have been payable to the serviceman if he had retired at the date of his death. Subsection 3 of that section of Section 7 says any pension payable under subsection 1 of this section shall be paid to any person entitled thereto for a period expiring at the end of 5 years after the death of the serviceman. So, however, that a lump sum representing 5 years' pension may be paid forthwith to the person entitled thereto. By this provision, 1 year's salary at the amount being earned by the officers as at the date by the officer as at the date of his death is the gratuity payable to a deceased officer's dependents, while the pension payable to the dependents of the deceased officer is the amount the officer would have been entitled to be paid as pension if he had retired at the date of his death. And by Section 7.3 of the Act, the pension is paid for a period of 5 years, 5 years after the death of the officer, or the 5 years lump sum is paid at once. It is clear from these provisions that the amount of the pension and gratuity of the claimant's deceased father can only be computed using the applicable scale as at the time of his death. Accordingly, what the claimant is entitled to be paid as his father's pension and gratuity is the amount of his father's salary at the time of his death in 1981 and to be computed pursuant to Section 7(1) and 3 of the Armed Forces Pension Act. In paragraph 17 of the Statement of Defense, the defendants admitted paragraph 34 of the Statement of Facts. Counsel submitted in paragraph 6.8 and 6.9 of the claimant's written address that the defendants have admitted that the claimant be paid using the current computation trend. The manner of computation and the relevant time for the computation have been determined by statute. The admission of the defendants cannot change or override the provision of statute. Neither can this court circumvent the provision of the Act. In Relief 3, the claimant sought for an order directing the defendants to waive the condition that he produces a letter of condolence, Nauticus, Unit Part 2 order, and service document before his father's pension and gratuity can be processed and paid to him. In this case, it is clear to me that when the claimant started pursuing payment of his father's pension and gratuity, the reason he was not paid was because he was unable to produce letter of condolence, Nauticus, Unit Part 2 order, service document, and affidavit of next of kin which the defendants required to process payment. Defendants did not dispute the fact that the claimant's father's pension and gratuity have not been paid. The defendants also recognized the claimant as the next of kin of his father. I do not think the fact that the claimant could not produce the documents should be a reason not to pay the pension and gratuity to the claimant. Section 173, subsection 2 of the 1999 Constitution directs that the pension and gratuity to which a person in the public service of the Federation is entitled to receive in accordance with or under any law cannot be withheld to his disadvantage except to such extent as is permissible under any law. The defendants have not shown that the requirements for presentation of letter of condolence, nauticas, unit part 2 order, and service document to process payment of pension and gratuity of a deceased officer is a requirement of any law. It implies that the defendants' insistence on seeing the documents before they pay is not a condition imposed by any law, and it has the ultimate effect of denying the dependents of the claimant's deceased father his pension and gratuity. What the defendants required, if not met, will mean that the pension and gratuity would have been withheld in breach of the provision of Section 173, subsection 2 of the Constitution. The provisions of Section 280 of the Armed Forces Act, cited by learned counsel for the defendants in paragraph 5.6 of the defendant's final address, is not applicable to pension and gratuity of a deceased officer. Section 173 of the Constitution is meant to protect the pension rights of persons who have served in the public service of the Federation, and this court has the corresponding duty to uphold and enforce those provisions of the Constitution. Accordingly, it is within the powers of this court to give orders whose purpose is to avoid situations where the provisions of Section 173 of the Constitution will be rendered nugatory. I find merit in Relief 3 sought by the claimant. In paragraph 11 of the statement of facts, the claimant averred that after the burial of his father, the third defendant never contacted any member of his father's family for payment of his pension and gratuity. The claimant also confirmed that no member of his father's family, also contacted the defendants for the payment of the pension and gratuity of his father until August 2022, when the claimant wrote Exhibit NA2. For 41 years, the defendants did not pay, and the claimant did not see the need to ask for payment until 2022. The defendants cannot be expected to make payment until the next of kin or dependent of the deceased shows up with proof of his entitlement to receive payment. When the claimant took steps to process payment, he was required to produce some documents to enable the defendants to make payment. From the evidence of the claimant, the defendants did not refuse to pay, and I have not seen any evidence to suggest that the defendant did not want to pay. They only asked the claimant to produce the required documents to enable payment be processed. In fact, the claimant pleaded in paragraphs 32 and 33 of the statement of facts that he was invited to a meeting on 14th August 2023, where the defendants told him payment of his father's pension and gratuity will be in the monetary amount of applicable in 1982. The dispute resulting to the defendant's failure to pay before this suit was instituted, as I see it, was the failure of the claimant to produce required documents, and the question of what to pay, the question of what to pay should be computed. Let me to say how much to pay. I do not think the defendants should be blamed for the non-payment of the pension and gratuity of the claimant's late father. In view of the above, I hold that the claimant failed to prove his claim in Reliefs 2 and 7. Same applies to Relief 8, where the claimant sought special damages in the sum of 50 million naira. The claimant did not prove the amount he claimed as special damages. Reliefs 1, 3, 4, and 9 succeeds. while reliefs 5 and 6 succeed to the extent only that the claimant is entitled to be paid the pension and gratuity of his late father at the amount of his father's salary at the time of his death in 1981, and to be computed pursuant to Section 7(1) and 3 of the Armed Forces Pension Act. Reliefs 2, 7, and 8 fail, and they are hereby dismissed. In conclusion, the court makes the following orders. 1. It is declared that the claimant, by virtue of the third defendant's letter dated 19th October 2022, is the recognized next of kin of his father, late Lieutenant Abakiri. Accordingly, the third and fourth defendants are ordered to extend to the claimant the rights and privileges which he is entitled to as next of kin of Lieutenant Abakiri. 2. The defendants are ordered to waive for the claimant the requirement of production of requisite documents for the processing and collection of his late father's pension and gratuity. Consequently, the defendants are ordered to compute the claimant's father's pension and gratuity in accordance with the provisions of Section 171 and 3 of the AFP Act and pay same to the claimant within 30 days from today. Cost of 1 million naira is awarded in favor of the claimant. Should the defendant not comply with the order in paragraph 3 and 4 above, within 30 days, interest of 10% per annum is ordered to be paid by the defendants until the amount due is completely paid to the claimant. Judgment is entered accordingly.
As the court pleases.
Court pleases.
As the court pleases.
As the court pleases.
As the court pleases.
As the court pleases.
We thank my Lord on behalf of the claimant. We thank my Lord for the well-considered judgment, and we pray that God Almighty will continue to guide and guide your Lordship in the course of your endeavor.
Thank you very much.
Thank you.
Thank you, my Lord. Thank you. So I'm making the corrections, and then I will ensure that you get your judgment today from the clerk of courts as soon as I finish sitting now.
Thank you, my Lord. We're very grateful. Yeah.
Thank you.
Thank you.
So give me a few seconds before we take the next matter. Yes. So that I can. Call the next case. Can you call the next case, please? Mohammed online. Tell him now. Let's see.
Yes, my lord.
Case number 2, my lord. NSN/ABJ/264/2025 between Incorporated Trustee Nigeria Bar Association and the Police Service Commission, Nigeria Police Force, Inspector General of Police, and Attorney General of Federation. My lord, parties absent.
Thank you, my lord. With profound respect, my lord, my name is Austin J. Otter, Esquire, for the claimant. Appearing with me, my lord, is Bulus, Bulus, Y for Yankee, Atsen. Atsen is spelled Atsen. Bulus,
Yes.
Y Atsen Esquire, and
Yes.
Vincent Adodo.
Yes.
For the claimants. We are very grateful, my lord.
Yes.
May my noble lord be pleased.
Yes.
Okoro Nachi Ediam.
Yes. Yes.
My lord, my humble appearance is for the first respondent. You are most obliged.
Yes. Yes. Any other appearance? Yes.
Yes, my lord. Respectfully, my lord. Abubakar A. Nuhu.
Yeah.
My humble appearance is for the third respondent, Honorable Attorney General of the Federation.
The sixth respondent, please.
Okay.
Yes. Mr. Ezekiel is not here. Rimam Sonte. Okay. Mohammed, did you reach out to him? Why is Mohammed not on the platform?
So did you reach out?
My lord, yes. I reached out to him. He said the judgment can be delivered.
Okay.
It's not.
Is to put it on flight mode. No, if you put it on flight mode, you are done. You know the work.
This is the judgment of the court.
Ask her, please.
Again, just to announce to you, this is a very lengthy judgment. As a matter of fact, it's a 54-page judgment. And a lot of it contains portions of the clause cited, quoted verbatim. So I'm going to skip those portions and go to only the portions of the judgment that relates to determination of the suit. And in doing so, I want to assure you that the judgment will be available for collection right after today's sitting. If you are in Abuja, and otherwise, you can get it on Monday.
Ask her, please.
Thank you.
As the court pleases.
So, the claimant, the Incorporated Trustees of the Nigerian Bar Association, instituted this suit via the originating summons on 3rd September 2025, wherein it submitted the following questions for determination. There are 7 questions for determination, which I have set out verbatim. Upon the determination of the above questions, the claimant sought the following reliefs against the defendants jointly and severally. There are 13 reliefs sought, and I have again listed them out verbatim on the body of the judgment. The originating summons was supported with an affidavit and a written address. In defense of the suit, the first defendant filed a counter affidavit with a written address on 24th February 2026, while the second to fifth defendants filed a joint counter affidavit and written address on 19th February 2026. The sixth defendant filed a written address only on 10th October 2025. The claimant filed 2 further affidavits together with replies on point of law on 24th February 2026 and 4th March 2026, respectively. So, the first thing I will do is to determine the preliminary objections. There are 2 preliminary objections filed in the suit. The first one was filed by the first defendant on 24th February 2026 to challenge the jurisdiction of this court to entertain this suit, while the second one was filed by the claimant on 4th March 2026 to challenge the competence of the claimants of the counsels appearing for the first defendant on one hand and counsel appearing for the second to fifth defendants on the other hand. It is observed that the notice of preliminary objection of the claimant to the competence of the said counsel for the defendants also touch on the competence of the processes filed by the first to fifth defendants, including the PO filed by the first defendant. Although the notice of preliminary objection of the first defendant has to do with the jurisdiction of this court, it cannot be heard until the competence of the counsel who filed it is determined. It is therefore necessary to first determine the NPO of the claimant to ascertain whether or not the legal representation for the first to fifth defendants and the processes filed by them are competent. The claimant's notice of preliminary objection, which was brought under Rule 8(1) and 2 of the Rules of Professional Conduct, sought the following reliefs. There are 5 reliefs sought in the claimant's notice of preliminary objection. I have cited them verbatim. The notice of preliminary objection was supported with an affidavit and written address. In opposing it, the first defendant filed a counter affidavit and written address on 13th April 2026. The second to fifth defendants too filed a counter affidavit and written address on 15th April 2026 to oppose the notice of preliminary objection. So I have gone ahead to summarize the facts and addresses in support, both in support and in opposition to that notice of preliminary objection of the claimant. I will therefore proceed straight to the decision on the NPO of the claimant, while skipping those portions I've summarized. They are already embodied in the judgment. The decision on the PO of the claimant. Rules 8(1) and 2 of the Rules of Professional Conduct 2023 provide as follows. A lawyer, while a servant or in a salaried employment of any kind, shall not appear as advocate in a court or judicial tribunal for his employer, except where the lawyer is employed as a legal officer in a government department. Sub 2, a lawyer, while a servant or in a salaried employment, shall not prepare, sign, or frank pleadings, applications, instruments, agreements, contracts, deeds, letters, memoranda, reports, legal opinion, or similar instruments or processes, or file any such document for his employer. By these provisions, a lawyer in a salaried employment as a civil servant can only appear in court as an advocate for his employer and to prepare, sign, and file court processes on behalf of his employer if he is employed as a legal officer. It is not in dispute that Babatunde Dada, Aisha Hassan Abdul Kadir, and Okoro Nnachi Ibiam are lawyers and civil servants in the salaried employment of the first defendant. They prepared, signed, and filed the processes filed by the first defendant in this suit. My records also show that Okoro Nnachi Ibiam and Aisha Hassan Abdul Kadir have appeared in this suit as counsel, representing the first defendant. Also, it is a fact that Rimamsonte Ezekiel is a lawyer and an officer in the salaried employment of the second defendant. He prepared, signed, and filed processes in this suit on behalf of the second to fifth defendants. From my record, Rimamsonte has been appearing in this suit as counsel representing the second to fifth defendants. The objection of the claimant is that Babatunde Dada, Aisha Hassan Abdulkadir, Okoro Nachibiam, and Rimamsonte Ezekiel were not employed as legal officers, and they are therefore prohibited by Rules 8.1 and 2 of the Rules of Professional Conduct from appearing in court on behalf of their employers and from preparing, signing, or filing processes in this suit on behalf of their employers. Thus, the issue whether or not Babatunde Dada, Aisha Hassan Abdulkadir, Okoro Nachimbiam, and Rimamsonte Ezekiel can appear in court as counsel for their employers and to file processes on behalf of their employers depend on whether or not whether they were employed as legal officers by their employers. Now, in the counter affidavit of the first defendant, it was averred that Babatunde Dada, Aisha Hassan Abdulkadir, and Okoro Nachi Ibiam were employed as legal officers by the first defendant. I have seen exhibits PSC 1, 2, 3, and 4 of the first defendant's counter affidavit. PSC 4 is the appointment letter of Babatunde Dada. He was employed as a legal officer by the first defendant. Exhibit PSC 3 is the promotion letter of Babatunde Dada to Director Legal. Exhibits PSC 1 and 2 are the appointment letters of Aisha Hassan Abdulkadir and Okoro Nachi Ibiam. They were both appointed legal officers by the first defendant. In view of exhibits PSC 1, 2, 3, and 4, Babatunde Dada, Aisha Hassan Abdulkadir, and Okoro Nachi Ibiam were appointed legal officers of the first defendant. By Rule 8.1 and 2 of the Rules of Professional Conduct, they are competent to appear in court as counsel to represent their employers and to prepare, sign, or file processes in court on behalf of their employer. Accordingly, I find no merit in prayers 2 and 4 sought by the claimant in the notice of preliminary objection. On the part of Rimamsonte Ezekiel, it was stated in the counter affidavit of the second to fifth defendants that he is a legal officer in the second defendant and that he has been converted to a specialist in the Nigerian police force by the exhibits A, NPF A and B. From what was stated in the counter affidavit of the second to fifth defendants, Rimamsonte Ezekiel was not employed as a legal officer in the second defendant, but was converted to a legal officer or specialist. Reliance was placed on exhibits NPF A and B of the counter affidavit. I have examined the exhibits NPF A and NPF B. Rimamsonte was mentioned only in exhibit NPF B, which is a police wireless message, reference DTO 031015/07/2025. It is a posting order of senior police officers. Rimamsonte was posted to the position of Assistant Director, Criminal Litigation, Legal, Force Headquarters, Abuja. By this posting to Assistant Director in the Legal Department of the second defendant, Rimamsonte Ezekiel was clearly designated as a legal officer in the second defendant. He may not have been employed initially as a legal officer in the second defendant, but his subsequent deployment and designation as legal assistant director qualifies him as a legal officer. I so hold. Accordingly, by Rules 8.1 and 2 of the Rules of Professional Conduct, Rimamsonte Ezekiel is competent to appear in court as counsel to represent the second defendant and to prepare, sign, or file processes in court on behalf of the second defendant. For these reasons, I find no merit in prayers 1 and 3 sought by the claimants in the notice of preliminary objection. The result is that the NPO lacks merit and it is hereby dismissed.
Ascop, please.
Now to the PO of the first defendant. In the NPO of the first defendant, it sought an order striking out or dismissing the suit for want of jurisdiction. The grounds of the PO are stated below, and it is supported by affidavit and written address, which I have summarized under. I will again go straight to I have again also summarized the claimant's response to the PO as contained in the affidavit and written address in support. I'll go straight to the resolution of that preliminary objection. But first, I will touch on the first defendant's reply on points of law. The first defendant filed a reply on points of law where it presented this new issue for determination, considering the circumstances surrounding the claimant's arguments, whether the first defendant's appeal should be sustained in this case. The first defendant cannot raise a new issue in his reply on points of law as the issue to be determined in the appeal. It is also observed that the submissions made in paragraphs 3.1 to 3.3 of the reply with respect to the issue of the claimant's local standing, the submissions made in paragraph 3.12 to 3.16 of the reply with respect to the issue of non-service of pre-action notice, and the submissions made in paragraphs 3.19 to 3.21 on the unsuitability of originating summons to commence this suit are repetitions of the arguments already contained in the written address in support of the appeal. Furthermore, the submissions made in paragraph 3.4 to 3.6 of the reply are new issues not arising from the written address in support of the claimant's counter affidavit. Also, in paragraphs 3.7 to 3.11 of the reply, learned counsel for defendants made new arguments on the issue of this first defendants, I must say, made new arguments on the issue of this suit constituting an abuse of court process in view of the previous actions filed on the subject matter of this suit. One of the grounds of the appeal is abuse of court process. Thus, the arguments contained in paragraphs 3.7 to 3.11 of the reply ought to have been made as substantive arguments in the written address in support of the appeal. Arguments on a ground of objection cannot be smuggled in through a reply on points of law when it was never addressed in the written address in support of the appeal. More so, that the other party does not have the opportunity to respond to the new arguments in the reply address. In my view, paragraphs 3.4 to 3.11 of the first defendant's reply on points of law are not competent. The concluding submissions in the reply on points of law, as contained in paragraphs 3.22 to 3.24 of the reply, is that Section 18 of the Police Act 2020, which the claimant wants the court to interpret, has been voided by the Supreme Court in NPF versus Police Service Commission 2024. Let me state here that these arguments are not in respect of any of the grounds of objection. The arguments are therefore irrelevant to the determination of the notice of preliminary objection.
Score, please.
Let's go, please.
So I'm going into the decision on the appeal of the first defendant. The appeal of the first defendant contains the following 5 grounds of objection. I have listed them out there. However, in the written address in support, only grounds 1, 3, and 4 were argued. The first defendant seems to have abandoned grounds 2 and 5 of the appeal. When I read the processes filed by the parties in this suit, I noticed that the first defendant raised some grounds of objection in its counter affidavit and written address to the originating summons. In paragraphs 30, 40, 34, 40, 45, and 47 of the first defendant's counter affidavit, it was averred that the claimant lacks local standing to institute the suit. The claimant has no cause of action against the first defendant, non-service of pre-action notice, that the suit was commenced by a wrong procedure. Although also issues A, D, F, and H of the written address in support of the first defendant's counter affidavit to the originating summons. Raised issues of lack of local standing. Abuse of court process, non-disclosure of cause of action, and non-service of pre-action notice. These grounds of objection raised by the first defendant in his counter affidavit and written address to the originating summons are similar to those raised in the notice of preliminary objection, except the grounds of non-disclosure of cause of action and abuse of court process deemed abandoned in the appeal. I've decided to consolidate all the grounds of objection raised by the first defendant and determine them at once in this ruling. From the first defendant's PO and its defense processes to the originating summons, the first defendant has raised these grounds of objection. There are 5 grounds listed there, and I will consider each of the grounds of objection seriatim. Ground 1, the claimant in this suit is the Incorporated Trustees of the Nigerian Bar Association. By the way, ground 1 is that the claimant lacks local standing to institute the suit. The claimant in this suit is the Incorporated Trustees of the Nigerian Bar Association. The first defendant contended that the claimant lacks the local standing to institute the suit. The term local standing means the right of a party to institute an action and to appear in court and be heard on the questions he brought before the court. A party who brings an action before the court must disclose sufficient interest in the subject matter of the suit or in the outcome of the suit, or must show that he will suffer or stand to suffer an injury, either by the enforcement or threatened exercise of some power, authority, or right which he complained about in the suit. These are the facts which indicate that the party who institutes the suit has local standing in the suit. In DOPA versus Registered Trustees of UMCN 2019, it was held thus: local standing means the legal capacity or standing of a party to institute an action in a competent court of law or tribunal. Therefore, the challenge of a person's local standing in a case raises a question of whether the person whose standing is in issue is the proper person to seek the adjudication of the court or tribunal upon the issues involved in or the subject matter of the case. Where a party does not, quote and unquote, where a party does not have sufficient interest in the subject matter of the suit or in the outcome of the suit, or if he has not suffered or does not stand to suffer any injury, either by the enforcement or threatened exercise of some power, authority, or right which he complained about in the suit, he is said to lack local standing in the suit. See also East Horizon Gas Company Limited versus FIOC 2012. See Adetona versus Zenith International Bank 2012. I've considered the facts deposed to in the parties' affidavits in support, in parties' affidavits in respect of this ground of objection and the submissions made in the respective written addresses. However, the law is trite that the local standing of a claimant in a suit he has instituted is to be found in the endorsements in the originating processes, which in this case is the originating summons and the affidavit in support. Therefore, in deciding whether a claimant has local standing, the originating processes are to be examined to ascertain whether they disclose a course of action vested in the claimant. In First Bank of Nigeria PLC versus Nerico Enterprise Limited 2002, it was held that in an application to determine whether a plaintiff has local standing or not, the judge is bound to confine himself within the 4 walls of the writ of summons and the statement of claim before him, and no more, as the issue of local standing is a matter of law. Even if the statement of defense has been filed at the time the objection was made, the judge will still be bound to confine himself to the statement of claim of the plaintiff to decide whether he has a local standing. Unquote. On that note, I have examined the originating process to see whether the claimant has disclosed its local standing to institute this suit. In paragraphs 2, 3, 4, and 5 of the affidavit in support of the originating summons, it was deposed that the Nigeria Bar Association is the professional association of all legal practitioners in Nigeria, including lawyers in the Nigeria Police Force who are its members upon being called to bar. The motto of the NBA is, quote and unquote, promoting the rule of law. And being the conscience of the nation, the NBA has, as part of its statutory objects, the responsibility of challenging impunity, violation of the rule of law, and it is also dedicated to protecting the rule of law, democracy, and citizens' rights. The NBA is also the custodian of the laws and rules regulating the legal profession, and it monitors and enforces compliances. I have also read the facts deposed to in paragraphs 12 to 37 of the affidavit in support of the originating summons, where the reasons or the cause which necessitated the claimant to bring this suit was stated. The summary of the case of the claimant is that some police officers who later acquired legal training and became lawyers and members of the claimant were deliberately not appointed as legal officers or upgraded to legal officers or specialists by the first and second defendants in violation of Section 18, 9, and 11 of the Police Establishment Act and Force Order number 137. Yet, these police lawyers were being used for the work of legal officers to perform professional legal duties for the first and second defendants, an act which constitutes professional misconduct under Rules 8.1 and 2 of the Rules of Professional Conduct for Legal Practitioners. Some of these lawyers in the police force who dared to insist on their rightful placement were victimized. On the basis of these facts, the claimant wants the court to interpret some constitutional and statutory provisions to declare and enforce the rights of the police lawyers to be upgraded to legal specialists in the police force. The claimant also wants the court to enforce the provision of the Police Establishment Act, which mandates that legal practitioners be posted to each police divisions in Nigeria. It is clear from the facts of the case of the claimant that the claimant is not directly affected or interested in the subject matter of his complaint in this suit. Of course, that is why the first defendant asserted that the claimant does not have local standing. However, the law on local standing has now evolved to cover some individuals or bodies who institute actions of public interest nature, otherwise known as public interest litigation. In Center for Oil Pollution Watch versus NNPC 2019, the Supreme Court confirmed the shift in the conventional law on local standing when it held, thus, quote and unquote, in public interest litigation, the chambers of the Attorney General of the Federation traditionally hold sway. However, the law on local standing in that regard has grown beyond that and now encompasses public-spirited individuals and non-governmental organizations, unquote. See page 575 of the report. When further affirming the local standing of public-spirited individuals or associations or non-governmental organizations to bring public interest actions, the Apex Court held thus at page 597, quote, every person, including NGOs, public-spirited individuals or associations, has sufficient interest in ensuring that public authorities or corporations submit to the rule of law and that no public authority has power to arbitrarily or with impunity break the law or general statute. The right of the citizen or lawful associations to see that the rule of law is enforced vests in him or the association sufficient standing to request the law to call to order a public authority allegedly violating the law. There is such aspiration in Section 17(2)(a) of the extant Constitution, 1999, that provides that, quote, every citizen shall have equality of rights, obligations, and opportunities before the law, unquote. It is the view of the Supreme Court that every person, including NGOs and associations, who seek the due performance of statutory functions or enforcement of statutory provisions or public laws should be regarded as proper persons clothed with standing in law to request adjudication on such issues. From the facts of this case, the lawyers in the employment of the first to fifth defendants who are suffering oppression and marginalization are members of the claimant, and therefore the claimant has sufficient interest in their welfare and well-being. Again, the claimant's action seeks to prevent the defendant's continual violation of constitutional and statutory provisions as it relates to the members of the claimant in the employ of the first and second defendants. The suit of the claimant qualifies as public interest litigation and accordingly confers the claimant with local standing to institute and maintain the suit. Consequently, I hold that the claimant has local standing to institute this suit. The first defendant is overruled on this ground of the NPO.
As my Lord pleases.
The court pleases.
Ground 2. In issue 2 of the written address in support of the first defendant's counter affidavit to the originating summons, it was submitted that this suit is an abuse of court process in the sense that the parties and facts of this suit are the same with the processes filed in the Bayelsa and Owerri judicial divisions of this court. But the suits were discontinued by the police lawyers who filed the suit, who are now being represented by the claimant. It was submitted that the suits upon being withdrawn were dismissed. In paragraphs 14 to 20 of the affidavit in support of the PO of the first defendant, it was averred that in 2024, the legal police officer stroke specialists filed originating summons with suit number NICN OW 22-2024 between Inspector Surajo Mohammed and 5 others, suing for themselves and on behalf of other policemen who are used as specialists without being employed as such, and Police Service Commission and 3 others. The declarations and reliefs. Okay. The declarations and reliefs sought in that suit are the same being sought in this suit. The suit was later withdrawn via motion on notice dated 27 November 2024. The said legal police officers being represented by the claimants in this suit brought another originating summons with suit number NICN YEN 01-2025 between Inspector Emiku Kanu Agabi Esquire and 41 others, suing for themselves and on behalf of other policemen who are used as professionals stroke specialists without being employed for that purpose, and the Police Service Commission and 4 others. This suit too was withdrawn via notice of discontinuance dated 23 January 2025, but because the first defendant filed a counter affidavit to the originating summons, the suit was dismissed. The response of the learned counsel for the claimants in the claimant's reply and point of law is that the claimant was not a party to any of the cases referred to by the first defendant. It was also submitted that the said cases have been withdrawn and struck out. As such, the claimants in those suits are at liberty to refile the suit, and the new suit will not constitute an abuse of court process. Exhibits PSC1, PSC2, and PSC3 are the originating summons and motion for withdrawal filed in suit OW 22-2024, while PSC4 and 5 are the originating summons and motion for withdrawal filed in YEN 01-2025. PSC 6 and 7 are the memorandum of appearance and counter affidavit filed in YEN 01-2025. I've examined these exhibits. The claimant in this suit was not a party to suit OW 22-2024, YEN and YEN 01-2025. It is also clear from the averments of the first defendant that the suits are no longer pending in court. Although the first defendant claimed that the suits were dismissed, the first defendant did not exhibit the record of proceedings in the suits to buttress its assertion that the suits were dismissed. It is, however, clear that the suits were not dismissed on their merits. Upon withdrawal by the parties who filed the suit, a dismissal order will have the same effect as a striking out order. Such a suit can be filed again having the same parties or with different parties. Abuse of court process would arise when there is multiplicity of actions on the same subject matter between the same parties, or when different actions are instituted between the same parties simultaneously in different courts. See Okafor versus AG Anambra State 1991, Okpekun versus Sadiq 2003. It is clear to me that there was no pending suit in any court having the same parties, subject matter, and reliefs as this suit, as at the time this suit was filed. The claimant in this suit was also not a party in the previous suits. Let me mention also that this suit was not filed in a representative capacity. Accordingly, I do not find this suit to constitute an abuse of court process. This ground of objection fails.
As court pleases.
So now I'm going to ground 3. The first defendant sought that this should be dismissed because the claimant did not serve pre-action notice provided in Section 23 of the Police Service Commission Establishment Act 2001 on the first defendant before the claimant instituted this suit. It was submitted that the failure of the claimant to serve a pre-action notice on the first defendant before the claimant instituted this suit renders the suit incompetent. The fact that the claimant did not serve pre-action notice on the first defendant is not in dispute. However, the position of the claimant is that Section 23 of the Police Service Commission Establishment Act does not require service of pre-action notice on the first defendant, as the first defendant is not included in Section 23 of the PSC Establishment Act, as those requiring service of pre-action notice before a suit can be instituted against them. Section 23 of the Police Service Commission Establishment Act provides that no suit shall be commenced against any member of the commission, against a member of the commission, the secretary, officer, or employee of the commission before the expiration of a period of 1 month after written notice of intention to commence the suit shall have been served upon the commission by the intending plaintiff of his agent. This provision of the Police Service Commission Establishment Act is clear and unambiguous. It provides that before a suit can be commenced against a member of the first defendant, the secretary, officer, or employee of the first defendant, a 1-month pre-action notice must have been served on the first defendant by the intending claimant. Although the 1-month pre-action notice is required to be served on the first defendant, the suit for which a pre-action notice is required is that commenced against a member of the first defendant, the secretary, officer, or employee of the first defendant. The provision did not mention suit commenced against the first defendant. It implies that suit against the first defendant is excluded from the requirement of service of pre-action notice before it can be commenced. Since this suit is not commenced against a member of the first defendant, the secretary, officer, or employee of the first defendant, the claimant is not required to serve the notice in Section 23 of the Act before it can commence this suit against the first defendant. The first defendant is established by the Police Service Commission Establishment Act. If the legislature had intended the provision of Section 23 of the Police Service Commission Act to apply to suits filed against the first defendant, it would have been expressly stated in the provision. In National Examinations Council versus Tokode 2010, the Court of Appeal interpreted the provision of Section 19 of the NECO Act and held that since the provision mentioned suits against the officers, employees, registrar, and members of the board of NECO without specifically mentioning the National Examinations Council, National Examination Council is therefore not covered and excluded from the benefits of the provision of the section. Accordingly, the non-mention of the first defendant in the provision of Section 23 of the Act means that it is not intended to apply to suits filed against the first defendant. Therefore, the fact that the claimant did not serve a pre-action notice on the first defendant before commencing this suit does not render this suit incompetent. The first defendant is overruled on this ground of the PO.
As my lord pleases.
Ground 4. The contention of the first defendant on this ground of objection is that originating summons is not the proper procedure to be used to commence this suit in view of the fact that there is dispute of facts in the suit. Going by the provisions of Order 3, Rules 3 and 17(1) of the NICN Rules 2017, civil proceedings that may be commenced by way of originating summons are those principally on interpretation of the Constitution, enactments, agreements, or any other instrument relating to matters upon which this court has jurisdiction, including matters relating to employment. And for a declaration of the rights of the persons so interested in the enactment, agreement, or written instrument. Also, where a suit does not raise substantial dispute of facts or not likely to involve substantial dispute of facts, it can be commenced by way of originating summons. In Dapialong versus Darie 2007, it was held thus, quote, "The originating summons procedure is a means of commencement of action adopted in cases where the facts are not in dispute or there's no likelihood of there being a dispute, and when the sole or principal question in issue is or is likely to be the one directed at the construction of a written law, constitution, or any instrument or of any deed, will, contract, or other document, or other question of law, or in a circumstance where there is not likely to be any dispute as to the facts. In general terms, it is used for non-contentious actions or matters. That is, those actions where facts are not likely to be in dispute," unquote. I have examined the questions submitted by the claimant in the originating summons for determination. The relief sought and the facts deposed in the affidavit in support of the originating summons. This case is basically to construe the provisions of Section 42 of the Constitution of the Federal Republic of Nigeria, 1999, Sections 18, 9, and 11, and Section 66(3) of the Police Establishment Act 2020, First Order number 137 of the Ratified First Order 2013, and Rule 8(1) and 2 of the Rules of Professional Conduct for Legal Practitioners 2023, and thereby determine the rights of police officers who are lawyers to be upgraded as legal officers or as specialists in the service of the second defendant. In my view, this case is a matter that can be heard by way of originating summons. I've also examined the affidavits of the various parties. I have not seen any substantial dispute of facts that cannot be resolved using affidavit evidence. I hold, therefore, that the commencement of this action by way of originating summons is proper. This matter shall be heard and determined as originating summons proceedings. The first defendant is also overruled on this ground of appeal.
As my Lord pleases.
Ground 5. The first defendant also contended that the claimant has not disclosed any cause of action against it. The arguments on this issue are contained in issue F of the written address in support of the first defendant's counter affidavit to the originating summons. It was submitted on the issue that the first defendant has constitutional mandate for the appointment, promotion, discipline, dismissal, and control over police officers in Nigeria other than the Inspector General of Police, while the Inspector General of Police, who has the mandate to control the operations and the day-to-day service, while the Inspector General of Police has the mandate to control the operations and the day-to-day services of the Nigerian Police Force. It was submitted that the first defendant was not involved in the study arrangement of the police legal officers or specialists. Therefore, there is no cause of action against the first defendant, and the first defendant is not a necessary party in this suit, as it did not participate in the reappointment or redeployment of those officers as general duty officers, and the acts of the second to fifth defendants assigning duties to the police specialists other than what they were appointed for by the first defendant cannot be linked to the first defendant. From these submissions on the issue of non-disclosure of cause of action, the first defendant is already defending himself against the suit of the claimant itself. Against the suit of the claimant. In other words, the fact that the first defendant was not aware of the study arrangements of the police lawyers or was not involved in the assignment of duties to the police lawyers is a matter suitable to be canvassed in defense of the suit, rather than a matter of non-disclosure of cause of action against the first defendant. The first defendant confirmed that it is responsible for the appointment, promotion, discipline, and control of police officers in Nigeria, other than the Inspector General of Police. The issue in this suit involves the failure to employ police officers as legal officers or to upgrade them to specialists. The case of the claimant discloses a cause of action against the first defendant. The first defendant is also a proper and necessary party to this suit. Whether or not the first defendant will be liable for the claims sought by the claimant is another matter, which will be determined in the merits of the main case. In the final result, the PO of the first defendant clearly lacks any merit. It fails completely and it is hereby dismissed. Also resolved against the first defendant and accordingly dismissed are the points of objection raised by the first defendant in issues A, D, F, and H of his written address in support of his counter affidavit to the originating summons.
As my Lord pleases.
So I'm going straight now to determine the originating summons. In doing that, I have summarized the case of the claimants as well as contained in his affidavit in support of the originating summons, as well as the the written address of counsel filed in support. I've summarized that. I have again summarized the defense of the first defendant, as well as their written address. I have summarized the defense of the second to fifth defendants as contained in their affidavit and their written address. I see the need to read a portion of that part before I go to the main resolution. In the opening statement on paragraphs 4, 5, and 6 of the counter affidavit of the second to fifth defendants, the deponent said, the ACP Rimam Sonte Ezekiel of counsel in this case informed me in the office of 16 February 2026 at about 10:25 a.m. information which I agreed with him that the first secretary of the Nigeria Police Force and ACP Rimam Sonte Ezekiel of counsel further informed me in the office on the same date, and which time I agreed with them that the next paragraph, that I am also informed by ACP Rimam Sonte Ezekiel of counsel in this case and first secretary to the Nigeria Police Force at the same, which I agree that. I have summarized these 3 paragraphs and they are cited in the body of the ruling. According to learned counsel for the claimant, these statements did not meet the requirements of section 1153 and 4 of the Evidence Act. Earlier in paragraphs 1 and 3 of the counter affidavit, the deponent said he and ACP Rimam Sonte work in the same office, which is the Directorate of Legal Services of the second defendant at Area 11 Force Headquarters, Abuja. In paragraph 4, the deponent mentioned who gave him the information, the place, date, and time. He also said he agreed with the information received. The use of the word agreed, in my view, is an expression of the deponent's ground of belief in the information he received. Now, in paragraphs 5 and 6, the deponent said the facts deposed in those paragraphs were received from the first secretary of the Nigeria Police Force and ACP Rimam Sonte Ezekiel at the same place, date, and time. Although the said first secretary was not identified, the fact that one of the informants is identified is sufficient to allow the paragraph escape section 1153 and 4 of the Evidence Act. In my view, paragraphs 4, 5, and 6 have not offended the provisions of section 1153 and 4 of the Evidence Act. Section 12 of the NIC Act permits this court to depart from the Evidence Act in the interest of justice. However, what I find greatly offensive to the provisions of the Evidence Act, and which I cannot apply section 12 of the NIC Act to condone, is the several legal arguments, conclusions, and objections contained in the counter affidavit of the second to fifth defendants. The affected paragraphs are paragraphs 4, B and C, 5A, E, I, K, L, M, N, M, O, P, Q, R, S, T, V, W, and Z, section 16C and I, and paragraph 16C and I, and paragraphs 7, 8, and 9. An affidavit to be used in proceedings before a court as required in section 5, 1 and 2 of the Evidence Act shall contain only statements of facts. An affidavit is incompetent when it contains extraneous matter by way of objection, prayer, or legal argument or conclusion. See Bameyi versus the State, 2001. The depositions in paragraphs 4BC, 5A, EI, KL, MOP, Q, STV, WZ, paragraph 6C and I, paragraph 7, 8, and 9 of the second to fifth defendants' counter affidavit are not fit to be contained in an affidavit. The offending paragraphs are incompetent and are hereby struck out.
As my Lord pleases.
What the deponent stated in the counter affidavit of the second to fifth defendants, which qualify as statements of facts and conform to the standard of the Evidence Act, are that police lawyers who have been called to the Nigeria Bar are qualified to appear in the court as general duty officers to prosecute and also to defend the Nigeria Police Force in court. Police lawyers who were recruited as general duty and who are in the legal section of the Nigeria Police Force are defending and also prosecuting police cases in the court. Such police lawyers are not complaining and they did not request the Nigeria Bar Association to commence this action in court. All police lawyers in the Nigeria Police Force were all called to the Nigerian Bar and they are members of the NBA. As such, they are entitled, I'm quoting part of All police lawyers were all called to, and they are members of the Nigeria Bar Association. As such, they are entitled to practice and can appear in any court of law. The Nigeria Police Force. So this is what the rest of what I'm reading are content of the counter affidavits of the 2nd to 5th defendants, the ones that survived the striking out. I hope we all understand.
As a copy.
Yes, my lord.
So I think I should skip reading what is left of that part of the ruling and go straight to the 6 defendants' response to the originating summons, which is a very clear. There's need to make to read a portion of that consideration. The 6th defendant did not file a counter affidavit, but filed a written address only on 10th October 2025. It was submitted in the address that because this suit is about interpretation of provisions of the Constitution of Federal Republic of Nigeria 1999, the Police Establishment Act 2020, Force Order 1373 of the Ratified Force Order 2013, and Rules of Professional Conduct for Legal Practitioners 2023. The 6th defendant will rather respond as amicus curiae rather than as a defendant in the suit. On that note, the learned counsel who settled the address raised a lone issue for determination, to wit, whether by interpretation of Section 18(9) and 11 and 66(3) of the Police Establishment Act 2020, Order 137 of the Ratified Force Order 2013, and Rule 8(1) of Rules of Professional Conduct for Legal Practitioners 2023, in conjunction with Section 42 of the Constitution, whether this court will arrive at an informed decision on the questions submitted. I will leave the remaining part of that written address, as I have just verbatim summarized it, into the body of this judgment. And then the claimant filed the claimant filed further affidavits and reply addresses, which I have also summarized into the body of this judgment. At this point, I will proceed to the decision on the originating summons. And by the way, just so you know, we are just on page 38 of the judgment, and we are still going to 54. The claimant submitted 7 questions for determination in the originating summons. These questions constitute the issues to be determined. However, questions 1, 3, and 4 are the same in context and effect. I will consider them together as one issue, while questions 2, 5, 6, and 7 will be considered as separate issues. Determination of questions 1, 3, and 4. This issue involves determinations of questions 1, 3, and 4. That is issue 1 now. The background of this case is that some police officers who were employed by the first defendant as general duty police officers later, after their appointment as junior officers, went to school to acquire degrees in law, attended the law school, and were called to the Nigerian bar. Upon becoming lawyers, the 2nd to 5th defendants started using these officers for legal duties without upgrading them to legal officers or as specialists in the field of law. The legal duties performed by these police lawyers for the 2nd to 5th defendants include appearances in court to represent the Nigerian Police Force and filing of processes in court on behalf of the Nigerian Police Force. It is for these reasons the claimant wants the court to determine questions 1, 3, and 4 of the originating summons. The claims sought by the claimant on the basis of these questions are reliefs 1, 3, 4, 9, and 10. Reliefs 1, 3, and 4, including reliefs 2, 5, 6, and 7, are declaratory reliefs, declaratory claims, while reliefs 8 to 13 are ancillary orders sought pursuant to the declaratory claims. A heavy burden of proof is placed on a party seeking declaratory claim in the sense that such declaratory reliefs are not granted as a matter of course or even on admission by the defendant. The law is that in any suit where a party seeks a declaratory claim, such a party is required to prove the claim with cogent, credible, and satisfactory evidence. Accordingly, the success of a declaratory claim sought by a claimant depends on the quality of evidence adduced by him to prove the claims. The weakness of the defendant's case does not help the claimant's case in any way. See Zakala versus Edosa, 2018, Ada versus Ubandawaki 2015. In addition, sections 132 and 1331 of the Evidence Act place the burden of proof in a civil suit on the party who would fail if no evidence were given on either side. It implies that the burden of proof of the claim sought by the claimant in this suit is fixed on the claimant and will only shift to the defendants upon satisfactorily proving its claims. The main issue involved in questions 1, 3, and 4 of the originating summons is the claimant's complaint of failure to upgrade in rank or convert the police lawyers to specialist/legal officers after becoming lawyers, contrary to section 18(9) and 11 of the Police Act and Force Order number 137. Thus, the case of the claimant in questions 1, 3, and 4 calls for the interpretation and enforcement of the provisions of section 18(9) and 11 of the Police Act and Force Order 137. According to the claimant, those sections provided for the employment of specialists through professionals in the Nigeria Police Force for the purpose of discharging professional duties for the force. The Police Act also provided that personnel who have undergone professional training to be upgraded to the field of their profession accompanied with the deserving and appropriate rank should be upgraded to the field of their profession accompanied with the deserving and appropriate rank. However, police officers who later became lawyers while in the police force were not upgraded in rank to specialist or legal officers or superintendent ranks, yet being used to perform professional legal services or functions of specialist legal officers for the defendants. Upon reading the counter affidavit of the first defendant and that of the second to fifth defendants, it is observed that these defendants admitted the fact that some police officers, while in service, later acquired legal training and have become lawyers. They also admitted that these police officers, who were not employed initially as legal officers, upon becoming lawyers, were used by the second to fifth defendant to perform legal duties. However, what the second to fifth defendants stated in their counter affidavit to be the reason for not promoting or upgrading the affected officers is that promotion to another rank is not automatic, but depends on availability of vacancy. On its part, the defense of the first defendant is that the police officers who became lawyers while in service were appointed as general duty officers and not as legal officers. When the officers went to acquire further education, they did not obtain the permission of the first defendant, who is their employer, and they did not obtain approval for study leave, whether with or without pay, from the first defendant before obtaining any professional qualification. In other words, the first defendant claimed that it has no knowledge of the professional qualification acquired by the affected police officers. The first defendant also stated that upon acquiring additional professional/educational qualification, there are procedures in the public service rules for promotion to higher rank or conversion to specialist cadre in the police force, and the officers who satisfy the requirements are usually promoted or converted by the first defendant. In the case of the affected officers, they did not follow the due process in the public service rules, both in obtaining the professional qualification and in seeking promotion or conversion from general duty cadre to specialist duty cadre, as provided by the Federal Civil Service Commission Guidelines for Appointment, Promotion and Discipline, revised edition of August 2004. And as such, the first defendant cannot be compelled to promote or upgrade them. Having seen the position of the parties, I shall now examine the provisions of the law upon which the claimant founded his case. To that effect, I have verbatim cited the provision of Section 18 of the Police Service to Police Act 2020 in the Section 9, the subsections 9 and 11. I've cited them verbatim in this place. The above provisions are part of the entire Section 18 of the Police Act 2020. The section contains 11 subsections. The first defendant has raised a vital issue, which has to do with the validity and enforceability of the provisions of Section 18 of the Police Act, including subsections 9 and 11 thereof. In paragraphs 3.18 and 3.19 of the written address in support of the counter affidavit of the first defendant, the court's attention was drawn to the Supreme Court's decision in NPF versus PSC 2023, and it was submitted that Section 18 of the Police Act was declared null and void by the Supreme Court. According to learned counsel for the first defendant, the claimant cannot found its case on any provisions of Section 18 of the Police Act 2020 or rely on the section to seek any reliefs before this court. In response, learned counsel for the claimant submitted in paragraphs 4.27 of the claimant's reply on point of law that Section 18 of the Police Act was not submitted to the Federal High Court for determination in the case of NPF versus PSC, and the validity or otherwise of Section 18 did not arise for determination in the suit. It was also submitted that neither party in the suit sought any relief for the striking down of Section 18 of the Police Act. Therefore, according to the learned counsel for the claimant, the pronouncement of the Supreme Court on Section 18 is an obiter dictum and not the ratio of the decision in the suit. I have read the judgment of the Supreme Court in Nigeria Police Force and two others versus Police Service Commission and one other, 2024. While commenting on the unconstitutionality of Section 18 of the Police Act, His Lordship Tijani Abubakar JSC, who delivered the leading judgment, held thus at pages 304 to 305. Quote, the National Assembly made futile efforts in enacting the Police Act 2020 during the pendency of this appeal by specifically enacting Section 18(1) and 2, and all in effort to vest the power of recruitment in the second appellant in this appeal. This is another attempt at strangulating the respondents in this appeal. While it is within the powers of the National Assembly to make laws for the order and good governance in Nigeria, a legislation during litigation purposely made the legislation to meet the demands of power governments in flagrant disregard to the provisions of the Constitution. Any legislation made during litigation in contravention of the Constitution and enacted to steal a match against a litigant will be condemned and declared null and void. Section 18 of the Police Act 2020 is obviously unconstitutional and must be declared null and void. It is so declared, unquote. On his part, His Lordship Jauro JSC held at page 358 thus, quote, another offending provision is that contained in Section 18 of the Police Act 2020. The section provides that the responsibility for the recruitment of recruit constables into the Nigeria Police Force and recruit cadets into the Nigeria Police Academy shall be the duty of the Inspector General of Police. It also creates a recruitment committee for the recruitment of recruit constables into the Nigeria Police Force. Let me switch it off. It should be pointed out that the Police Act 2020 was enacted by the National Assembly during the pendency of the instant legal tussle. Section 18 of the Act, nevertheless, offends paragraph 30, part 1 of the third schedule to the Constitution, and just like the offending provisions of the Nigeria Police Regulations, it is bound to suffer the same fate of being declared void. You can close it so that it will retain the coolness. Section 18 of the Police Act 2020 is therefore declared void for being inconsistent with paragraph 30, part 1 of the third schedule to the Constitution, unquote. The Supreme Court, by this decision, has nullified and voided the entire Section 18 of the Police Act 2020. My lords had stated clearly that the Police Act 2020 was enacted by the National Assembly while the appeal was pending in the Supreme Court. It implies that the validity or otherwise of Section 18 of the Police Act 2020 was not part of the issues submitted for determination in the trial Federal High Court in the suit leading to appeal. This was the reason learned counsel for the claimant submitted that the declaration of the Apex Court was obiter. Now, should this court, on the basis of the submission of learned counsel for the claimant, overrule the Supreme Court and proceed to countenance Section 18 of the Police Act? Put in another way, can this court enforce the provisions of an act which the Supreme Court has voided? I do not think this court has such powers. The decision of the Supreme Court on Section 18 of the Police Act 2020 is a pronouncement on the constitutionality of the section. Therefore, the Supreme Court's declaration is not an obiter, as erroneously believed by the learned counsel for the claimant. What learned counsel for the claimant has asked me to do when he submitted that Section 18 of the Police Act was not originally a subject matter in the suit is that I should discountenance the decision of the Supreme Court and proceed to rely on Section 18 of the Police Act to determine its case. To accede to the suggestion of the claimant will mean that I will consider and enforce a provision of the Nigeria Police Act 2020, which has been voided by the Supreme Court. An attempt to do that will be tantamount to judicial rascality and an affront to the Supreme Court. I do not have the jurisdiction to review a decision of the Supreme Court, nor overrule the Supreme Court in its decision on Section 18 of the Nigeria Police Act 2020.
As a cop, please.
In view of the decision of the Supreme Court on Section 18 of the Police Act, the section remains voided and unenforceable until such a time that either the Supreme Court reverses the decision or the National Assembly amends the Act. None of these remedies, which can confer validity on Section 18 of the Act, has happened to my knowledge. Therefore, Section 18 of the Police Act remains a void section of the Act. Where a statute or a provision of statute is declared void, such a statute or part of it confers no rights, imposes no duty, affords no protection, and it is legally regarded as inoperative. See Okafor versus Attorney General Rivers State, 1998. The provisions of Section 18 of the Nigeria Police Act have no life or any statutory effect whatsoever, and no right or claim can be founded on it by the claimant or anybody else. See also Ejimofor versus Nitel, 2007. Consequently, the claimant failed in the aspect of its case founded on Section 18 of the Nigeria Police Act 2020. The claimant also founded its case on Force Order number 137. Page 149 of the ratified Force Order containing Force Order number 137 was exhibited as Exhibit A. The content of Force Order number 137 is as follows. I have a verbatim put in the provisions accordingly. I will skip that part. The claimant specifically relied on paragraph 3 of Force Order 137. The content of the order reveals it was made by the Inspector General of Police, who directed in paragraph 3 that personnel who acquired degree or HNDs in any specialized field for the purpose of promotion will automatically convert to such specialist department, quote and unquote. In other words, the IGP has directed the automatic promotion of police officers who acquire higher educational qualification while in service. The claimant wants this court to use this force order to declare that the police officers who became lawyers while in service are entitled to be promoted or upgraded to specialist positions. In paragraphs 8, 13, 14, 15, and 41 of the counter affidavit of the first defendant, it was deposed that the first defendant is the one who appoints and promotes police officers except the IGP, and that all police officers, including those who acquired additional qualifications, are entitled to promotion or conversion of service in accordance with public service rules, and that the first defendant follows the PSR in promoting police officers or in conversion of service. The first defendant also said it cannot be compelled to promote police officers without due process being followed. The claimant did not dispute these averments of the first defendant in his further affidavits. Paragraph 3 of First Order 137 is a directive for promotion and conversion or upgrade of police officers who acquired higher qualifications in specialized field. It was issued by the IGP, but the defendant said it is the one with powers to promote police officers and not the IGP. The claimant confirmed this fact in paragraph 6 of the affidavit in support of the originating summons and paragraph 6 and 8 of its further affidavit, where it stated that the first defendant is charged with the responsibility of appointment, promotion, and discipline of police officers except the IGP. There's the red, no, pillow. Sorry, learned and gentlemen. I need to adjust. Okay.
As a cop, please.
My lord, pleases.
The question, therefore, is who has the competence to give directives or regulation having to do with the promotion or conversion of police officers, and whether Force Order 137 made by the IGP is a valid directive on promotion of police officers. Before this court can rely on paragraph 3 of the Force Order 137 to determine the case of the claimant, these vital issues must first be resolved. The first defendant is established in Section 153(1)(m) of the Constitution. See also Section 1 of the Police Service Commission Establishment Act 2001. The powers of the first defendant is stated in paragraph 30 of the third schedule to the Constitution to include appoint persons to offices other than office of the IGP in the Nigeria Police Force and dismiss and exercise disciplinary control over such persons so appointed. Section 6 of the Police Service Commission Establishment Act further provides for the functions of the first defendant to include the following. A, to be responsible for the appointment and promotion of officers to offices other than the office of the IGP. 2, to dismiss and exercise disciplinary control over persons other than the IGP. And 3, to formulate policies and guidelines for the appointment, promotion, discipline, and dismissal of officers of the Nigeria Police Force. On the other hand, the office of the IGP was created in Section 215A of the Constitution, who by virtue of Section 215A of the Constitution is given, and by virtue of Section 215A of the Constitution, he is given the command of the Nigeria Police Force. Section 7 and 8 of the Police Act further detail the functions of the IGP. They are basically to exercise full command and operational control over the police force and all its departments and units. The Police Act also vested powers for making of standing orders in the police force. In Section 16(1), the IGP is empowered to make standing orders relating to operational control of the police, while the first defendant is empowered in Section 16(3) to make standing orders relating to the appointment, promotion, and disciplinary control over persons appointed into the police force. By virtue of the provisions of the Constitution and statutes examined above, the IGP has not been given any powers relating to the appointment or promotion of officers in the police force. He has also not been given any powers to make any standing order or regulation of policies concerning the appointment or promotion of officers. The functions of the IGP, including the standing orders he can make, are limited to operational control of the police force. On the other hand, paragraph 30 of the third schedule, Section 6 of the Police Service Commission Establishment Act, and Section 16(3) of the Police Act vest the first defendant with the powers to appoint and promote officers in the police force and to make policies or guidelines and standing orders with respect to their appointments, promotion of officers of the police force. From the foregoing, it is clear that the third defendant cannot make standing orders or regulation or guideline or anything of the form of force order which tend to regulate appointment or promotion of officers in the police force. Thus, Force Order 137 was made ultra vires the power of the third defendant, and it is accordingly not a valid instrument regulating promotion in the police force. It is also not an instrument binding on the first defendant. Accordingly, no police officer can rely on it as a basis to seek to be promoted by the first defendant. The summary of all I have said so far is that Section 18(9) and 11 of the Police Act and Force Order number 137, which the claimant relied on to seek for the upgrading or conversion of the police lawyers to legal officers or specialists, are defective and therefore of no useful purpose in the determination of the claims of the claimant. Accordingly, all the declarations and claims sought by the claimant on the basis of Section 18(9) and 11 of the Police Act and Force Order 137 fail completely. Besides the fact that the claimant based his case on defective provisions of a statute and an instrument, I have also seen from other facts available in this case that its claim for the promotion or upgrade or conversion of the police officers who became lawyers is not based on compliance with due process and procedure for promotion in the public service of the Federation. The claimant simply wants the affected officers promoted or upgraded automatically without showing that the procedure to do so, as provided in the condition of service regulating the employment of persons in the police force, were followed. It was averred in the counter affidavit of the first defendant that the provision of the public service rule regulates promotion and conversion of service in the police force. In the claimant's further affidavit and reply on points of law, it did not deny the facts that The public service rule regulates the employment of officers employed into the service of the police force. It is therefore not in dispute that the public service rules regulates the employment of all police officers, including those who the claimant is agitating for their upgrading. The public service rules is a subsidiary legislation having been made pursuant to powers conferred by the Constitution. See Federal Civil Service Commission versus Laoye, 1998. See also Federal University of Technology, Yola versus Mewuya, 2013. I'm entitled to take judicial notice of the public service rules. Rules 020, 802, 803, and 804 of the Public Service Rules 2021 set out the procedure and requirements for promotion. That means promotion in the police force is not automatic. A process is followed to promote officers in the police force. In this case, the claimant simply wants the police officers, police lawyers to be promoted or upgraded in view of the qualification in law they obtained during the employment without satisfying the court that the affected police officers have gone through the process for promotion or upgrade set out in the public service rules. This court lacks the powers to promote the said police officers and cannot order the first defendant to promote them automatically without complying with the procedure provided for such purpose in the public service rules. The result of the foregoing is that questions 1, 3, and 4 are answered in the negative and against the claimant. Reliefs 1, 3, 4, 9, and 10 sought by the claimant are lacking in merit.
As the court pleases.
Now I go to the determination of question 2. The issue the claimant wants the court to determine in question 2 of the originating summons is founded on the provision of Rule 8.1 and 2 of the Rules of Professional Conduct for legal practitioners. The complaint of the claimant is on the issue of using the police lawyers to perform legal duties when they were not employed employed as or upgraded to legal officers, specialists, contrary to Rule 8.1 and 2. The rule provides as follows. I've read that before, so I'll just go on. The provision of Rule 8.1 and 2 is self-explanatory. A lawyer who is in a salaried employment as a civil servant, except where he is employed as a legal officer, cannot appear as counsel in court for his employer or carry out professional legal duties, which include preparing or signing off or filing court processes or legal documents for his employer. According to the claimant, the police officers who have become lawyers during their employment in the police force were not employed as legal officers and cannot appear in court or carry out professional legal duties without being appointed or upgraded to legal officers. However, such police officers have been appearing before superior courts of records for the prosecution of cases or defense of civil actions for the defendants, and also carry out professional legal duties for the defendants when they were not appointed as legal officers or upgraded to legal officers. In paragraph 35 of the affidavit in support of the originating summons, names of 43 police officers were mentioned to say that the said officers are in the police force, deployed to the legal department, are performing professional legal duties, prosecuting and representing the defendants in courts as legal practitioners, while they were not employed as such. The claimant contended that the conduct of these police officers are doing the conduct of cases these police officers are doing constitute professional misconduct and makes them liable to be prosecuted before the legal practitioners disciplinary committee for representing their employers when they were not employed as legal officers or upgraded as specialists or legal officers. The first defendant said in his counter affidavit that it usually appoints legal practitioners directly into the Nigeria Police Force, and it employed its own legal practitioners who represent it in legal matters. But it is the third defendant who uses the police officers who were not appointed as legal officers for legal duties, and this was done without the consent or approval of the first defendant. On their part, it was stated in the counter affidavit of the second to fifth defendants that police lawyers who have been called to the Nigerian bar are qualified to appear in the court as general duty officers to prosecute and also to defend the police force, and they are entitled to practice and can appear in any court of law. It was averred further that such police lawyers have been defending and also prosecuting police cases in line with the provisions of Police Act and the Constitution of the Federation. In support of the position of the second to fifth defendant, their counsel referred to Section 66, 1, 2, and 3 of the Police Act and submitted that the provisions give that these provisions give police lawyers the constitutional right to appear in the court of law as police lawyers to defend and also to prosecute for the police force. In the claimant's reply on points of law, it was submitted that Section 66 of the Police Act deals with prosecutorial powers and it authorizes a public officer who is a legal practitioner to prosecute in certain circumstances. Section 66(1) of the Nigeria Police Act 2020 provides as follows. I have outlined it there verbatim. This provision empowers a police officer who is a legal practitioner to prosecute criminal cases in any court for the Nigeria Police Force. By this provision, a police officer who is a legal practitioner is empowered to do all such acts or take all such steps incidental to prosecution of criminal cases in court, including appearing in court, preparing and filing of processes or documents in court towards the prosecution of such cases. The implication of the provision of Section 66(1) of the Police Act is that this prosecutorial power of a police officer who is a legal practitioner is exercisable whether or not he is employed as a legal officer in the police force. His qualification to prosecute is the fact that he is a legal practitioner and a police officer. The Police Act is an act of the National Assembly. Its provisions supersede the provisions of the Rules of Professional Conduct for Legal Practitioners, which was made by the Bar Council. However, the provision of Section 66 of the Police Act is limited to prosecution of criminal cases. It does not extend to any other legal duties not connected to prosecution of criminal cases. Thus, Section 66(1) of the Police Act is not a cover for a police officer not employed as a legal officer to carry out any other legal duty not connected with prosecution of criminal cases. In other words, other than to prosecute criminal cases, a police officer who is a lawyer by effect of Rule 8(1) and 2 of the Rules of Professional Conduct cannot appear in court for any other matter or prepare, sign, or file processes or legal documents unless he is appointed or designated or promoted as a legal officer. In this case, it is not in dispute that the said police officers who are legal practitioners are civil servants in salaried employment of the Nigeria Police Force. I also find clear evidence from the claimant, the first defendant, and the second to fifth defendants showing that these police officers, after becoming lawyers, but without being upgraded to the status of legal officers by the first defendants, have been acting and performing duties of legal officers for the Nigeria Police Force. The actions of these police officers who are legal practitioners but not employed or upgraded to legal officers violate Rule 8(1) and 2 of the Rules of Professional Conduct for Legal Practitioners 2023. Question 2 of the originating summons is therefore answered in the affirmative and in favor of the claimant. Reliefs 2, 8, and 11 have merit.
As the court pleases.
As my Lord pleases.
Determination of question 5. In question 5, the claimant asks whether by virtue of Section 18(9) and 11 of the Police Act and Force Order 137 and Rule 8(1) and 2 of the Rules of Professional Conduct, all the cases prosecuted by police officers who are not employed as legal officers for and on behalf of the police force are not a nullity and liable to be set aside. Then in reliefs 6 and 13, the claimant sought these claims. I have reeled out the content of those reliefs there. I have stated earlier in this judgment that the police officers who are lawyers are permitted to prosecute criminal cases in court and to perform all such legal duties incidental to prosecution of criminal cases. Now, with respect to any other matter or case that is not related to criminal prosecution, the claimant has not mentioned any such cases or provided evidence of any case handled by the said non-legal police officers. When the claimant sought in Relief 6 that I make a declaration that all matters or cases prosecuted in courts are not legal duties or actions or assignments carried out or performed by police officers not employed as legal officers are null and void, The duty vests on the claimant to present specific evidence of such matters or cases conducted in court and the legal duties or assignments carried out by the said police officers. In the absence of such proof, the court cannot make the declaratory order sought by the claimant or make an order setting aside cases or duties performed when I have not been shown evidence of any case where any police officer who is not a legal officer acted as a legal officer. The court cannot nullify an act that has not been shown to exist or have been done. The result is that the claimant failed to prove the claims sought in Relief 6 and 13. Question 5 is resolved in the negative and against the claimant.
As a couple.
Now to question 6. I have also considered question 6 of the originating summons and relief 7 sought by the claimant on the basis of the question. The claimant relied on the provisions of Section 42 of the Constitution to assert that the failure of the defendants to upgrade the police officers who have become lawyers to legal officers or specialists, while junior officers who have undergone professional training in engineering, medicine, aviation, accountancy, and other specialized fields were promoted or upgraded to deserving ranks, amounts to discrimination and violated the rights of the said police officers against discrimination. The claimant mentioned instances where other professionals were promoted over the police lawyers. In paragraphs 27, 28, 29, and 30 of the affidavit in support of the originating summons, it was deposed that a police signal reference number SH465/FS/FHQ/ABJ/VT/96 dated 4th July 2022 called for air wing pilots personnel who were junior officers and now have been regularized and upgraded to the rank of Deputy Superintendent of Police. There was also a signal issued by the defendants in 2016, which upgraded junior officers in the police force who were medical practitioners with MBBS to the rank of Superintendent of Police. In addition, medical doctors, engineers, accountants, and pilots who qualified in 2016 and 2022 were upgraded to Deputy Superintendent of Police. It was also mentioned that in April/May 2022, junior officers who are engineers in the police force were upgraded to the rank of Superintendent of Police. The deponent mentioned a Sergeant Ifeanyi, who, because he later attended Nnamdi Azikiwe University, Awka, and graduated between 2018-2019, was upgraded to rank of Superintendent of Police. In proof of these allegations, the claimant relied on the documents marked Exhibit C and D. I have stated earlier in this judgment that the claimant cannot found any claim on the provisions of Section 18, 9, and 11 of the Police Act and Force Order number 137. Therefore, the fact that the defendants did not apply the provisions to upgrade the police officers cannot amount to discrimination. Again, I have examined the Exhibit C and D relied upon. By the claimant. Exhibit C is a police wireless message communicating approval of the first defendant for the promotion and upgrade of some police officers to DSPs. Exhibit D is a press release for the promotion of some police officers by the first defendant. The first defendant has, however, established that it promotes officers only in accordance with the procedure for promotion in the public service rules. It is clear to me that the promotions in Exhibit C and D were not automatic as claimed by the claimant. Thus, for the claimant to succeed in its allegation that the failure to promote the said police officers who are lawyers amounts to discrimination, it must show that the said police officers went through promotion procedure and still were not promoted or upgraded. There is no such evidence from the claimant. The claimant did not also show that the officers in Exhibit C and D or any other police officer for that matter were promoted automatically without undergoing promotion procedure in the public service rules. What the claimant considers to be discrimination arose from its desire to have the police officers who became lawyers promoted automatically by the first defendant without applying the provisions of the public service rules on promotion. In my view, the mere fact that police officers have become legal practitioners while in service does not entitle them to automatic promotion or upgrade to specialist position. Consequently, the claimant failed to prove that non-promotion or upgrade of the police officers upon becoming lawyers is discriminatory. I find that the defendants have not breached the said police officers' rights against discrimination in Section 42 of the Constitution. Question 6 of the originating summons is resolved in the negative and against the claimant. Relief 7 also fails, having not been proved.
As the court pleases.
Yes, now to question 7. Question 7 of the originating summons sought the court to determine whether the defendant's refusal to deploy lawyers who are policemen to every police division in Nigeria is not a clear violation of the provision of Section 66(3) of the Police Act. It is the case of the claimant that Section 66(3) mandated the defendants to assign to every police division at least one police officer who is qualified to practice as a legal practitioner. But the defendants have refused to post legal practitioners employed into the police force to any of the police divisions in Nigeria. It's on the basis of this fact that the claimant's Relief 12 which is for an order compelling the defendants to deploy and station at least one police officer who is a lawyer to a police division in Nigeria to assist with the enforcement of human rights in policing at the division as provided by Section 66(3) of the Police Act. Again, the content of Section 66(3) is verbatim cited there in full. This provision is mandatory. It mandates the posting and placement of police officers who are lawyers in every police division in Nigeria. While the claimant maintained that the defendants failed to comply with this mandatory requirement of the law, only the 2nd to 5th defendant claimed in paragraph 5X of their counter affidavit that police lawyers are all over the country and serving in various police divisions, area commands, state commands, zonal commands, and legal section. The 6th defendant, who is the chief law officer of this country, did not dispute the claimant's assertion. The duty imposed in Section 66(3) of the Police Establishment Act is the responsibility of the 1st, 2nd, 3rd, and 6th defendants to ensure that what the Act mandated is carried out. Accordingly, the burden to satisfy this court of compliance with the provision is that of the 1st, 2nd, 3rd, and 6th defendants. Other than the mere statement in paragraph 5X of the counter affidavit of the 2nd to 5th defendants, no concrete evidence is placed before the court to show that there is assigned or posted to each of the police division in Nigeria a police officer who is a lawyer. Now, when it was deposed in the counter affidavit of the 2nd to 5th defendants that police lawyers are serving in police divisions, etc., I expected them to produce to the court a list of the names of police lawyers and the police divisions, area commands, and state commands, and so on, to which they are assigned. No such evidence has been shown to this court. Consequently, nothing has been placed before me by the defendant from which to believe that each police division in Nigeria has a police officer who is a lawyer assigned there. It is therefore clear to me that the defendants have been in violation of the provisions of Section 66(3) of the Police Establishment Act 2020. Consequently, I resolve question 7 of the originating summons in the affirmative and in favor of the claimants. The failure of the defendants to comply with directives of the Police Act justifies an order of court to compel them to perform the mandatory duty imposed on them by the Act. Reliefs 5 and 12 sought by the claimants have merit and they are granted accordingly.
As a court
Thankfully, we are now on page 53. Having carefully considered and resolved all the questions submitted for determination in the originating summons, I find merit in reliefs 2, 5, 8, 11, and 12 only. All other claims did not succeed and they are hereby dismissed. The court orders are as follows. 1. It is declared that police officers who are lawyers but not appointed or upgraded as legal officers in the Nigeria Police Force are in breach of the provision of Rule 8(1) and 2 of the Rules of Professional Conduct for Legal Practitioners 2023 by their actions of functioning and performing the duties of legal officers other than the duties of prosecution of criminal cases for their employer. 2. It is declared that the 1st, 2nd, and 3rd defendants have a mandatory duty to deploy police officers who are legal practitioners to every police division in Nigeria to assist with the enforcement of human rights in policing at the divisions, as mandated in Section 66(3) of the Police Act 2020. 3. An order is made restraining all police officers who are lawyers but not appointed or upgraded to legal officers in Nigeria Police Force from parading themselves as legal officers or carrying out the duties, functions, and responsibilities of legal officers for the Nigeria Police Force, except in prosecution of criminal cases as permitted in Section 66(1) of the Nigeria Police Act. 4. The first, second, and third defendants are directed to forthwith comply with the provisions of Section 66(3) of the Police Act 2020. By deploying and assigning to every police division in Nigeria at least one police officer who is a lawyer to assist with the enforcement of human rights in policing at the division. Parties shall bear their respective costs. Judgment is entered accordingly.
As the court pleases.
As the court pleases.
As my Lord pleases, we are very grateful and we've taken note of the judgment, my Lord.
Yes, you should be able to get a copy of your judgment.
Thank you, my Lord.
Thank you very much, my Lord. We are truly grateful.
Mr. Adson, is that you?
No, this is Mr. Otter, Austin Otter.
Mr. Otter,
Yes, ma'am.
You agree with me that you gave me a very huge work to do?
That is why we salute your judgments, my Lord. You have really, we have learned a lot from this judgment, and we are looking forward to applying what we have learned today in the future. Thank you very much.
Yes, you will not be delayed at all. Learned counsel, all of you, you get the copy of your judgment. Perhaps you want to take steps beyond this level. I'm sure that it is always good. This, some of these judgments, the purpose is to expand the law or put things right, or make the relevant parties do the needful.
Yes. Yes.
So, but if it is not started like this, so I commend you for taking this bold step to answer questions that seem to take care of so many gray areas that seem to exist in our laws. And I hope that we hear the ultimate decision when at the appropriate time. Yes. So
yes, my Lord. We will take everything under advisement. We will look at it, and if there is any need for us to take it further, we will. But at this time, we really appreciate your industry and everything that has been put into this judgment. I'm sure I speak on behalf of the other parties as well.
Yes, thank you very much.
So I'm much obliged.
Thank you. Yes. So I'm going to rest for like 10 minutes before I resume on the platform to continue with the other judgments.
Permission to leave the platform.
I'm sure you know that I deserve a bottle of water at this point.
Oh, certainly.
And Kununzaki, my Lord.
Thank you very much. I'll see the rest of you later. Have a good morning to the rest of you.
And you too, my Lord. And you too, my Lord.
Thank you.
Yes, my Lord.
Thank you.
Okay.
Yes, my Lord. On behalf of the first responder.
Yes.
We are most obliged for this.
Thank you.
It was well.
Thank you. Thank you very much. All right. I'll see you soon, the rest of you.
No, it's not everything. Sometimes I will say the file, my lord did not talk about their process. No, this one will take everything. Yes, sir. As I know, it will be concept of course. That's the part, it will not be first week of October.
What I'm saying now, because if you keep it now by next week, you get other matters.
Honest. And this is one of the best judgments you have made so far. Apa? Hello? Okay. You see, you have not looked up. Yes, minute.
Anna Mohammed. Oga Mohammed. What number are we on? Lamba nawa za mu shiga? Hello?
Yeah. Okay. This is 79. Maybe stick up a little. Okay, I'm back to you.
You are welcome back, man.
Thank you. Okay, Mohammed, can you call the case? The next case.
Case number NS/APJ/79/2026 between Rekia Gambo Iliashi and Head of Service of Federation and Minister of Education. Not parties are.
Okay.
No.
Appearances, please.
Hello. with the utmost respect and humility to your lordship. My name is Barka Bitrus, my lord. My appearance is for the claimant.
Yes.
May my noble lord be pleased. T.D.
Yes.
Agbe. T.D. Agbe, Assistant Chief State Counsel, Federal Minister of Justice, my lord. My humble appearance is for the defendants.
Assistant Chief State Counsel.
Yes, my lord.
So this is the judgment of the court.
As the court pleases.
As the court
In
pleases.
an originating summons filed by the claimant on 6 March 2026, the claimant submitted the following questions to this court for determination. There are 3 questions framed there, of which I have placed verbatim on the body of the judgment. Upon the determination of the above questions, is leave sought, which I have also verbatim put on the face of the judgment. Then the case of the claimant has been summarized, as well as his written address in support of the originating summons. In case of the defense of the defendant as contained in the counter affidavit has also been summarized, and as well as the written submissions which they have, which is embodied in their written address in support of their counter affidavit. Then the claimant filed a further and better affidavit and a reply on points of law, which I have again summarized in the body of this judgment. I will therefore proceed to the decision part of the judgment. The claimant submitted 3 questions for determination in the originating summons. This court will equally adopt the 3 questions as issues to be determined in this judgment. I will consider questions 1 and 3 together, while question 2 will be considered separately. What the claimant wants this court to, now the resolution of questions 1 and 2. What the claimant wants this court to determine in questions 1 and 3, rather, of the originating summons are as follows. Please give me a second. One, whether having regard to the provisions of sections 2 and 4 of the Harmonized Retirement Age for Teachers in Nigeria Act 2022, whether the claimant is entitled to compulsory retirement upon the attainment of 65 years of age or after 40 years of pensionable service. And question 3 is whether, issue 3 is whether having regard to the circumstances of this case and by any interpretation of the Harmonized Retirement Age for Teachers whether the claimant, being a teacher, can be compulsorily retired before the attainment of 65 years of age or 40 years of service. In these questions, and having regard to the arguments made in the written address in support of the originating summons, the claimant has called for the interpretation of the provisions of Rule 020908 and 909 of the Public Service Rules 2021 and Sections 2, 3, and 4 of the Harmonized Retirement Age for Teachers in Nigeria. In this judgment, I shall refer to the Public Service Rules as the PSR and the Harmonized Retirement Age for Teachers in Nigeria Act as the HRATN Act. In determining the questions, the starting point is to examine the set provisions of the PSR and the HRATN Act. I have highlighted the provisions of Rule 020908 of the PSR verbatim, and next is the provision of Rule 020909 of the PSR. Then sections 2, 3, and 4 of the HRATN Act have also been posted copiously on the face of the judgment. I'll proceed from there. The case of the claimant is that she was born in 1963 and joined the civil service of the Federation on 6 January 1989 as an education officer. She also said she rose to grade level 17 and was promoted to the position of a director in the University Education Department in the Federal Ministry of Education. The claimant produced a promotion letter to director as Exhibit RK1, dated 23 September 2019. Her promotion to director was with effect from 1 January 2018. According to the claimant, as an education officer, she is a teacher within the meaning of the word as defined in the HRATN Act. And by the provisions of the Act, her retirement age has been extended to 65 years of age or 40 years of pensionable service. She has not served for 40 years and has not reached the age of 65 years when on 10 February 2026, 24 February 2026, and 26 February 2026, the defendants issued circulars with reference numbers HCSF/3065/volume1/225, FME/S/1333/C16/T/18, and FME/S/1333/C16/22, directing all directors who have spent 8 years and above in the position of director on grade level 17 or its equivalent to proceed on retirement in compliance with Rule 020909 of the PSR. The circulars are exhibits RK3, RK5, and RK6. This is where the dispute arose. The claimant's complaint in this suit is that she is affected by the circulars as she is now being compelled to proceed on retirement, even though she was not eligible for compulsory retirement yet, by virtue of the extended retirement age for teachers in the HRATN Act. As a result, the claimant brought this suit for the court to determine whether she can be retired from service using the tenure policy for directors under Rule 020909 of the PSR, when by the provisions of sections 2, 3, and 4 of the HRATN Act, she, a teacher within the meaning of the Act, is entitled to retire at 65 years or of age or 40 years of pensionable service. On the other hand, the defendants contended that the claimant was retired from service based on the mandatory 8-year tenure policy applicable to all directors in the Federal Public Service as provided in Rule 020909 of the PSR, which requires a director who has served for 8 years on the post to retire from service, even if he or she has not attained the mandatory retirement age. It was also contended by the defendants that the HRATN Act provides the retirement age for teachers and education officers who are not directors, but the 8-year tenure policy applies to teachers and education officers who are directors, but such that teachers and education officers who are directors must compulsorily retire from service upon serving 8 years in the post. and not when they attain 65 years of age or 40 years of pensionable service provided by HRATN Act for teachers. I've carefully examined the facts and arguments canvassed by the parties in support of their respective positions. From the facts contained in the affidavits filed by the parties, the following facts are not in dispute. The claimant is an education officer in the Federal Ministry of Education. She was promoted to the position of director effective 1st January 2018. As a public servant, the PSR applied to the employment of the claimant. The HRATN Act extended the retirement age of teachers from the existing 16 years of age or 35 years of service in the PSR to 65 years of age. Or 40 years of service. It is also not in dispute that the defendants issued circulars in exhibits RK 3, 5, and 6, by which the claimant is expected to retire from service upon serving 8 years in the post of director pursuant to 020909 of the PSR. It is not in doubt that Section 2 of the HRATN Act fixed the compulsory retirement age for teachers at 65 years of age or 40 years of pensionable service. This extended age of retirement by virtue of Section 4 of the Act applies to any person who falls within the definition of teacher, including education officers. In paragraph 5 of the affidavit in support of the originating summons, the claimant averred that she is an education officer. The defendants did not dispute the fact that the claimant is an education officer. Accordingly, the provisions of the Act applies to the claimant. The Act defines teacher to include education officer. The claimant is therefore entitled as an education officer to retire compulsorily from service when she attains 65 years of age or 40 years of pensionable service, whichever comes first. I held this same view in the judgment I delivered on 26 February 2025 in NICN ABJ 69 2024 between Afolake Otaiwo versus the head of civil service of the Federation, head of service of the Federation, and 3 others. A copy of the judgment is attached to the affidavit in support of the originating summons as Exhibit RK8. In the judgment, based on the proper interpretation of Section 2 of the Act, I held at page 11 of the judgment that the provisions of the Harmonized Retirement Age for Teachers in Nigeria Act apply to the claimant as an education officer. She is entitled to compulsorily retire from service upon the attainment of 65 years of age or 40 years of pensionable service. However, the case of the claimant in the instant suit is that she was directed to retire from service upon serving in the post of a director for 8 years. This is not the same as the case in Suit BJ 69, where the claimant was not retired from service, but redeployed from the department in the ministry to a school. Thus, the issue whether an education officer who is a director should retire from service upon serving 8 years as director, pursuant to Rule 020909, was not considered or determined in Suit BJ 69. Accordingly, the decision in Suit BJ 69, other than to have merely declared the right of anyone within the meaning of teacher to benefit from the extended retirement age, does not resolve the issue in this suit. Therefore, the fact that the claimant as an education officer is entitled to the retirement age in the Act is not the conclusion of the issue in this matter. The claimant got to the position of a director in the Federal Ministry of Education, and Rule 020909 provides that a director shall compulsorily retire upon serving 8 years on the post. This is where the main issue in this suit lies. The question is whether, upon serving in the position of director for 8 years, whether the claimant is not expected to retire from service pursuant to Rule 020909 PSR, or she is to retire only when she attains 65 years of pensionable service, or pursuant to Section 2 of the Act. The contention of the defendants is that although the Act extended the retirement age for teachers and education officers, the extension does not apply to teachers and education officers who got to the position of director. According to the defendants, the tenure policy in 020909 PSR applies to all directors of whatever cadre, specialization, or classification, and that the provision of Section 2 does not affect the tenure policy. What the defendants are saying in effect is that any person who, although a teacher or education officer, was promoted to director, must retire from service upon serving as a director for 8 years, irrespective of the fact that the person has not reached 65 years or 40 years of pensionable service. In response to this position of the defendant, the claimant stated in her further affidavit that the act exempts her from the tenure policy in the sense that after serving as director for 8 years, she is not entitled to retire until she either attains 65 or have served for 40 years. In the claimant's reply on points of law, her counsel argued that the Rule 020909 on the tenure of directors is inapplicable to teachers in view of Section 3 of the Act, which provides that this public service rule or any legislation that requires a person to retire from the public service at 60 years of age or after 35 years of service shall not apply to teachers. The PSR 2021 provided in Rule 020908 sub 1 and 2 that the mandatory retirement age for all grades in civil service shall be 60 years or 35 years of service, except officers whose condition of service may have exempted them from the mandatory requirement age in Rule 020908 1 and 3. 020908 subsection sub rule 1. Sub rule 3 of Rule 020908 recognizes that certain officers are exempted from the retirement age of 60 years or 35 years of service. The rule specifically mentioned judicial officers, academic staff of universities, and other officers whose retirement age is different from that prescribed in Rule 020908 sub 1. That is to say, the retirement age in sub rule 1 will not apply to other officers whose retirement age is prescribed differently by statute. One of such officers whose retirement age has been recently varied from the retirement age is in Rule 020908 are teachers. The HRATN Act was enacted in 2022 specifically to increase the retirement age of teachers from the retirement age provided in 020908 of the PSR 1. Section 3 of the Act emphatically provides thus: the public service rule or any legislation that requires a person to retire from the public service at 60 years of age or after 35 years of service shall not apply to teachers in Nigeria. This provision is clear. It exempts teachers from the retirement age provided in the PSR. In other words, teachers or education officers cannot be retired from service before they reach 65 years of age or before they reach 40 years of service. Now, Rule 020909 of the PSR provides that a director of his equivalent, by whatever nomenclature it is described in MDAs, shall compulsorily retire upon serving 8 years on the post. This is the provision under which the defendants sought to retire the claimant. By Rule 020909 of the PSR, a teacher who became a director is expected to retire compulsorily from service upon serving for 8 years as a director, whether the teacher has not reached 65 years of age or has not served for up to 40 years at the time. Section 3 of the Act, which is clear to the effect that any provision of the public service rule that requires a teacher to retire before he is 65 or before serving for 40 years shall not apply to teachers. Thus, Section 3 of the Act has ousted the application of any provision of the PSR, including Rule 020908, which retires a teacher to retire from service before reaching the retirement age prescribed in the rule. The Rule 020908 of the PSR is no longer applicable to teachers by the effect of Section 3 of the HRATN Act. Consequently, a teacher who is a director does not retire any longer under Rule 020909 of the PSR. Serving as a director for 8 years is not a retirement condition for teachers any longer. A teacher's retirement age, whether as director or not, is only and strictly as provided in Section 2 of the HRATN Act, which is upon attaining 65 or 40 years of service. The first defendant seems to know the implication of the HRATN Act on the director's tenure policy and had implemented it earlier. I have seen the first defendant letter, reference number OHCSF/HOS/70260, dated 30th October 2025. which the claimant exhibited and marked Exhibit RK7. According to the claimant, in the year 2025, when implementing the 8-year tenure policy, the second defendant stopped the salaries of some affected directors, but the first defendant wrote Exhibit RK7 to the second defendant to convey approval based on the provisions of the HRATN Act, which states that the Act overrides any other legislation that contradicts it, including the 8-year policy. In response, the defendants admit that the first defendant issued Exhibit RK7. They, however, contended that there is no evidence that the appeal was granted or that the defendants reversed or modified the tenure policy. I have examined the content of Exhibit RK7. It was written by the office of the first defendant to the second defendant's ministry. Paragraph 2 of the letter, which the claimant relied on, reads as follows. Quote, the approval is based on the provisions of the Harmonized Retirement Age for Teachers in Nigeria Act 2022, which states that the Act overrides any other legislation that contradicts it, including the 8-year policy, unquote. The first defendant therefore directed the second defendant in paragraph 3 of the letter to liaise with the Office of the Accountant General of the Federation for the restoration of salaries and payment of accrued salary arrears owed to the officers, unquote. The first defendant took the position in Exhibit RK7 that the Act made the tenure policy inapplicable to directors in the Ministry of Education who are teachers or education officers. And it was on that basis it gave the directives in paragraph 3 of the letter. The first defendant cannot therefore be heard in this case taking a different position. The first defendant cannot approbate and reprobate on the same issue. By Exhibit RK7, the first defendant clearly acknowledged that the extended retirement age for teachers in the HRATN Act affected the director's tenure policy and made the policy no longer applicable to teachers. From the foregoing, it is my view that a teacher or education officer, whether he or she got to the post of director or not, is entitled to retire from service on attaining 65 years of age or 40 years of service. A teacher or education officer cannot be retired from service earlier than the retirement age provided in Section 2 of the HRATN Act on the guise of applying the director's tenure policy. Accordingly, questions 1 and 3 of the originating summons are resolved in favor of the claimant. Now, question 2. In paragraphs 9, 11, 12, and 13 of the affidavit in support of the originating summons, the claimant deposed that the first defendant issued circular number HSF 3065 volume 1/225 dated 10th February 2026 titled Implementation of the 8-year tenure policy for directors in ministry, extra ministerial departments and agencies pursuant to Rule 020909 of the Public Service Rules 2021, quote and unquote. And in implementing the circular in the Ministry of Education, the second defendant published circular reference number FME/S/1333/C16/T/18 dated 24th February 2026, directing all directors in affected cadres who have spent 8 years and above on posts as directors grade level 17 or its equivalent to proceed on retirement. The second defendant also published another internal circular reference number FME/S/1233/C16/22 dated 26 February 2026 to remind all affected officers to proceed on retirement immediately. It was on the basis of these facts the claimant submitted question 2 of the originating summons for determination. She wants the court to determine whether the circulars are not illegal, unlawful, and inconsistent with the provisions of the HRATN Act 2022. The circulars are exhibits RK3, RK5, and RK6. Their content contain a directive to all directors who have spent 8 years and above in the position of director on grade level 17 or its equivalent to proceed on retirement in compliance with Rule 020909 of the PSR. These circulars are meant to implement the tenure policy while resolving questions 1 and 2 of the originating summons in this judgment, I stated that the tenure policy as it relates to teachers is affected by the HRATN Act. Therefore, any act, letter, circular, or instrument issued for the purpose of implementing the tenure policy with respect to teachers or education officers are invalid and illegal for being inconsistent with the provisions of the Act. Accordingly, Exhibits RK3, RK5, and RK6, which are meant to implement the tenure policy against the teachers who are directors, are invalid, unlawful, null and void to the extent to which they relate to teachers or education officers. / Question 2 is also resolved in favor of the claimant. In the final result, the case of the claimant succeeds. Reliefs 1, 2, 3, 4, 5, 6, and 7 sought by the claimant are granted in these terms. 1. It is declared that by virtue of the Harmonized Retirement Age for Teachers in Nigeria Act 2022, teachers in general and the claimants in particular are entitled to compulsorily retire from the upon the attainment of 65 years of age or after 40 years of pensionable service. 2. It is declared that the first defendant circular number HCSF 3065/volume 1/225 dated 10 February 2026. The second defendant circular number FMES 1333/C16/T/18 dated 24 February 2026. And the second defendant's internal circular number FMES 1333/C16/22 dated 26 February 2026 are inapplicable to teachers to that extent, illegal, null, and void. And to that extent, illegal, null, and void. 3. An order is made setting aside the first defendant circular dated 10 February 2026. The reference is cited. The second defendant circular dated 24 February 2026 and the second defendant's internal circular number FME dated 26 February 2026 to the extent to which they relate to and affect teachers. 4. An order is made restraining the defendants from giving effect to the first defendant circular dated 10 February 2026, the second defendant circular dated 25 February 2026, and the second defendant's internal circular dated 26 February 2026, and from compulsorily retiring teachers and the claimants in particular in a manner inconsistent with the provisions of the Harmonized Retirement Age for Teachers in Nigeria Act 2022. Parties shall bear their respective costs. Judgment is entered accordingly.
As the court pleases.
As the court pleases, my lord, we are most grateful for this well-considered decision. Thank you so much, my lord.
Thank you. You get a judge. Thank you.
My lord, we are
Mr.
very
Agbe?
grateful for the... Yes, my lord. We are grateful for the judgment. Thank you, my lord.
Thank you. Yes, you get a copy within the day as soon as they bring them for me to sign.
Thank you so much.
They are now being transmitted to the registry. But the latest, the worst scenario, you get it on Monday.
Thank you, my lord. We're most grateful.
Thank you. So, Mohammed, call the next case.
Case number NSCN/MN/08/2021. Mr. Charles Bade and National Examination Council. Noted.
Appearances. Are the parties represented?
Parties
Mohammed.
Parties absent, my lord, but the parties are incumbent.
Appearances.
May it please the court?
Yes.
I am M.M. Shehu, holding the
Yes.
brief of Job J.O. Okebe.
Yes.
Announcing my appearance for the claimant, my lord.
Thank you.
You're
Yes.
welcome, my lord.
Any representation for the defendant? Did you call them?
Yes, Lord. I saw TK online.
Are they in court?
I believe. And some of the networks that are there online.
No. Is that there's no appearance for the defendant or what?
Maybe TK has.
Yeah.
You're not seeing it then. But Jimai Bashir is still online. Director of police.
But you said parties are absent. Is she appearing for the
defendant? Yes.
Good morning, my lord.
Good morning. That's Jumai.
Yes, ma'am. Yes, my lord. I
So
mean,
you are
far away. Ilori. That's why I'm watching.
You are representing the defendant.
Yes, ma'am. Yes, my lord.
I can make a call.
Hello. Hello, good morning.
Good morning.
Hello, so sorry. I'm having terrible network issues here.
Okay.
I'm trying to change locations for so long. I have to enter my car. Chike and Nairobi for the defendant. Hello.
Okay. Chike and Nairobi. Thank you. So I'm going to proceed to deliver my ruling.
My lord, the matter is slated today for ruling, and we are ready to take
Wasn't I the one that called you? You have to say that. I told you I was going to. It was not even slated for today. I think I slated it for 17 July. I sent you hearing notice yesterday or a day ago. If I didn't have anything to do, would I call you here? So I'm going to proceed to deliver the ruling of the court.
Okay. Yeah.
On 12th May 2026, I directed parties to address me on whether this suit has not become academic in view of the observations of the court that the defendant filed a written address on 19th May 2026. The claimants did not file a written address. Counsel for the claimants, Mr. Job Okebe, informed the registrar of this court via phone call in the morning of 18 June 2026 when the address came up for adoption that the claimants will rely on the written address filed by the defendant. I've heard the submissions made in the written address filed by the defendant. When the claimants filed this suit on 21st December 2021, the claims they sought were as follows. A declaration that the transfer of the claimants from the national headquarters of the defendants in Minna to Lagos and Borno State's offices of the defendant, respectively, is a fallout of suit number NICN MN06-2021 instituted against the defendant, and it is thus done in bad faith, malicious, vindictive, and amounts to undue punishment, unfair labor practice, workplace victimization, suppression of workers' rights, and an abuse of power or office. A declaration that the transfer of the claimants from national headquarters of the defendant to Lagos in Minna to Lagos and Borno State's offices of the defendant, respectively, via the letters dated 9 December 2021, is in breach of public service rules. 3. A declaration that the failure of the defendant to respond to the claimant's request for reversal of the transfers on health ground amounts to approval of the request, and the claimants were right to remain in their offices. Amounts to approval of their request, and the claimants were right to remain in their offices and duty posts at the headquarters of the defendant. 4. An order of court setting aside the transfer of the claimants via the letters dated 9 December 2021. And 5. An order restraining the defendant from taking any disciplinary action whatsoever. These claims have not been tried, but during the pendency of the suit, the first claimant retired from service of the defendant, while the second claimant, although still in the service of the defendant, had transferred to Borno State in this. Please, can you mute your mic, please? Although still in service, had transferred to Borno State in December 2021, which was her course of action in this suit, has been reversed. She is now reassigned to an office in Minna, where the headquarters of the defendant is situated. Because of these changes in the circumstances of the case, the claims sought by the claimants have been spent, and the suit no longer has any live matter in it to be adjudicated upon. Even if the suit is heard to conclusion, the decision on the claims of the claimants will hold no value or benefit to the claimants, nor will it affect the parties in any way, as the course of action upon which the suit was founded no longer exists. In a suit where a situation of this nature occurs, the suit is said to have become academic. See Adekunle versus AG Osun State 2018, Aldo versus INEC 2017. It is my view, therefore, and I agree with the learned counsel for the defendants, Buhari Bello Esquire, that this suit is now purely academic. Courts only entertain and determine suits which have live issues. Let me remove the name because it didn't appear before me. Courts only entertain and determine suits which have live issues or suits which have existing rights of the parties for determination. In other words, the courts do not waste precious judicial time considering such suits that have become academic. See Plateau State versus Attorney General of the Federation, 2006. Consequently, the proper order to make in the circumstances of this case, as rightly submitted by learned counsel for the defendant, is a dismissal order. Accordingly, this suit is hereby dismissed. No order as to cost. This is the decision of the court and it is entered accordingly.
As the court pleases.
As court pleases.
As the court pleases, we are most grateful for this wonderful ruling. Thank you.
So we go to the last one.
Case number NSCS/APJ/08M/2025. Oladil and National Gallery of Art and Board of Management, National Gallery of Art and Honorable Minister.
Parties are present.
Okay, parties present.
So defendants are represented by whom?
Okay, sorry, my lord. Sorry, I made a mistake. My lord, the claimant applicant is available. Yes, my lord.
Appearances.
Yes, with humility to my noble lord. Emeka C. Initials Ezeganya, spelled Ezeganya.
Yes.
My lord, I appear alongside O.E. Ngu. Ngu is spelled Ngwu.
Yes.
My lord, together we hold the brief of Tony Itejere for the claimant applicant. May I please record?
Only appearance for the defendants.
I see.
Okay, so I'll deliver the ruling.
On
25th May 2023, this court delivered judgment in suit ABJ 2243-2022 between Mr. Adejobi Adesoji, Adewumi, Olajide, and National Gallery of Arts and 4 others. These orders were made in the judgment. It is declared that due process as provided in Section 36 of the Constitution and the Public Service Rules was not observed by the defendants by withholding the promotion letter of the claimant since March 2022 and his salary from May 2022, and all such actions are therefore unlawful, illegal, null, void, and of no legal consequence. 2, it is declared that by virtue of Section 36 of the Constitution and the Public Service Rules, the defendants lack the value, and same is therefore unlawful, illegal, null, and void, and of no legal consequence. 3, it is declared that the withholding of the claimant's promotion letter since 1st March and full monthly salary from May 2022, despite the approval and recommendation of promotion of claimant by the second defendant, is a violation of the 1999 Constitution and the Public Service Rules, and same is null, void, and of no legal consequence. 4, an order is made setting aside the withholding of the claimant's promotion letter dated 1st March 2022 and his full monthly salary from May 2022. 5, an order is made directing the first, second, and third defendants to jointly pay the sum of 1 million naira to the claimant as general damages for the instability they have caused the claimant. And 6, an order is made directing the first, second, and third defendants to forthwith release the promotion letter of the claimant to Assistant Director on grade level 15 to him and pay him his salary from May 2022 together with arrears of his promotion from 1st January 2021. The court also ordered that orders 4 and 5 must be performed within 30 days from the date of judgment, being 25th May 2023. By a motion on notice filed on 12 February 2025, the judgment creditor applicant sought these reliefs and ordered that the contemnors are in disobedience of the orders made by this court on 25th May 2023 in the judgment delivered in ABJ 243. An order that the contemnors, being in contempt of the judgment, are liable to be compelled to obey the orders made by this court. 3, an order directing the contemnors to comply with the orders. 4, an order that the refusal of the contemnors to pay the judgment creditor his salary arrears, judgment sum, and release of his promotion letter on the ground that he must first withdraw his libel suit against the first judgment debtor at the FCC High Court, or any other reasons, conditions, is a total disregard to the 1999 Constitution. 5, an order of committal to prison of Ahmed Sodangi, Director General, National Gallery of Art, Ogbodo Evaristos Uzo, Acting Director, Finance and Account, Vonsir Ramjul Jesse, Acting Director, Legal Services, and Aliabi Ismail Adewale, Acting Director, Admin and Staff Development, for the persistent disobedience of the court order made on 25th May 2023 pending when they comply fully with the orders. 6, an order for 500,000 naira costs jointly and severally against the contemnors being caused for this application and for such order as this court may deem fit. Now, while this motion was pending, I directed the parties to file affidavits to inform the court of the level of compliance with the judgment by the judgment debtors respondents. I also referred the matter to the court's ADR Center for Mediation and Settlement of Outstanding Issues. The parties filed affidavits as directed by the court. The respondent's affidavit was filed on 27 February 2026, while the applicant's affidavit was filed on 5th March 2026. The ADR Center also mediated between the parties and forwarded its report dated 8 April 2026 to this court. When the matter came up before this court on 19 June 2026, Learned Counsel for the judgment creditor informed the court that mediation has failed, and counsel proceeded to move the motion of 12 February 2025. Ruling on the motion is today. I've examined the affidavits of the parties and the ADR reports. The respondents informed the court in their affidavits that the judgment creditor applicant has been restored into the payroll and has been receiving his monthly salary from October 2024. The promotion letter of the judgment creditor applicant to the position of Assistant Director has been released and the promotion was implemented in IPPIS. The judgment creditor applicant has been further promoted to Deputy Director on 24th November 2025. As for payment of the monetary aspect of the judgment, the respondents said they have requested funds from the budget office to pay the judgment creditor applicants withheld salaries, and they have also written reminders. On 22nd September 2025, the judgment creditor applicant was paid 500,000 naira as part of the damages awarded in his favor. On his part, the judgment creditor applicant said his salary was reinstated in October 2024, but the salaries he was paid was for grade level 14. It was from January 2025 that he was being paid salary for grade level 15. He also said his actual salary arrears and entitlements from May 2022 to September 2024 have not been properly calculated and paid. He confirmed that the respondents have completed payment of the sum awarded to him as damages. In the ADR report, I can see that the parties were willing to settle the outstanding issues amicably, and did agree on some terms. What the judgment creditor applicant proposed were as follows. 1, that the judgment creditor applicant will be paid his outstanding salaries and arrears in the sum of 12,892,613.67. 2, that the judgment debtors shall ensure that the above sum is paid to the judgment creditor within 30 days from the date the memorandum of settlement is signed by the parties. 3, that failure to pay the sum on or before 30th May, the sum shall thereafter attract a compound monthly interest of 25% of the total sum. 4, that the sum or any such interest shall be credited to the bank account of the judgment creditor applicant. 5, that the payment of the above sum by the judgment debtors shall be without prejudice to the payment of any other entitlements payable to the colleagues, and same shall be promptly paid to the judgment creditor. And 6, that the judgment debtor respondents may apply for extension of the payment period 1 week from 30th May 2026 by not more than 30 days by each of the judgment debtors by the registry of the court, stating the respective steps each of the defendants have taken to ensure that the above sum is paid. From the affidavits of the parties, the only aspect of the judgment left to be complied with is the payment of the appropriate arrears of salary of judgment creditor applicant. So, just a minute. In item 1 of the ADR report, the outstanding salaries and arrears of the judgment creditor applicant is said to be in the sum of 12,892,613.67. This seems to be the amount arrived at by the parties during the ADR as the total outstanding salaries and arrears due and payable to the judgment creditor applicant. Now, only items 2 and 3 of the proposed terms were not agreeable to the judgment debtors. And their reason was that the sum due to the judgment creditor is to be paid by the Office of the Accountant General of the Federation and not by the judgment debtors' respondents. As such, they cannot guarantee that the money will be paid within 30 days. They could not also undertake to pay 25% on the sum, since they were not the ones to pay. It was these two areas parties could not agree on before the ADR Center. It is clear to me that the only area remaining to be performed in the judgment is the payment of the arrears of salaries of the judgment creditor applicant, and the sum has been ascertained. Let me mention that the judgment creditor does not have the competence to impose interest on the salary arrears by himself. The parties were referred for ADR to resolve outstanding issues arising from the judgment and not to make new claims not forming part of the judgment of the court. Thus, the interest of 25% he proposed at ADR as a condition to resolve issues is unlawful. I have also seen that the judgment debtors are desirous to see that the claimant is paid his arrears of salary, and they have taken steps with the concerned authorities towards payment. Since the payment is not coming from the judgment debtors, insisting that the computed amount be paid within 30 days from the date the memorandum of settlement is executed is unrealistic and not within the mandate of the judgment debtors' respondents to commit. As it is, there is the need to know the outcome of the letters written to the budget office and to the Office of the Accountant General of the Federation with respect to payment of the arrears of salary of the judgment creditor before a decision is made on this motion. The proper thing to do in the circumstance is to adjourn this matter to another date to enable the judgment debtors respondents furnish this court with information on the progress made in the payment of the arrears of salaries due to the judgment creditor applicant. It is so ordered. So that's it. That's it. So I'm going to give you a date for report of compliance. Give me my diary.
Please.
So of this ruling and order hereby made on the judgment debtors, and this order automatically compels them to give us a feedback on the letters they have written to their Accountant General's office and whether they have been responded to. So we'll come back. Yes. October 13 for report of compliance.
October 13. October 13 is convenient.
Okay. What is this case number? Take it. Take it. ABJ 08M. So, Leonard Counsel, you know that you have work to do, right?
Yes, my lord.
Okay. The case is adjourned to 13th October 2026 for report of compliance.
As court pleases. My lord, we are very grateful for your fairness in the job.
Thank you very much. When you begin to commit people for contempt just because you have not seen the cash flow, how will the cash flow come out?
My lord,
So
we took the step because the defendants refused to take cogent step. My lord, it's just letter that they went and dumped at Accountant General's office, and nobody was.
So now that they have been ordered to give us a feedback on that.
Yes, that's why I said it's a fair.
Yes, exactly. All right, so we will send your judgment. Your ruling should be ready before the end of today, or latest at best by Monday.
We appreciate, my lord.
Thank you very much. So on this note, I will exit the meeting room.
As court pleases.
Thank you.